Welcome, everybody. I hope everybody is doing well. Today's class is the 2024 Georgia Association of Realtors, or GAR, or GAR, Contract Dissection class. It is GREC, Georgia Real Estate Commission, course number 77063. I'm your instructor, Dana Sparks. I am the broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America, which is the school offering this course for CE credit. We have previously taught a class on the 2024 GAR contract changes, which highlighted everything that the GAR Forms Committee changed from the 2023 contract package to the 2024 contract package. Today's class is going through the contract in and of itself. So today I am going, you guys, I could be here for hours and months, weeks and months on end going through every form of the contract package. We do have other classes, one that will be coming out soon on just the brokerage agreements, and one that will be coming out soon on just the exhibits and the amendments and other very interesting forms that GAR has available to you as an agent in their contract package. Today's class, we are going to cover specifically the purchase and sale agreement, the loan contingency agreements. That's the focus for today's class, as well as handling earnest money. So that would include the termination agreements, the release agreements, and perhaps some of the other commonly used exhibits. But the main focus is purchase and sale and financing. So let's get started, and I will cover questions and attendance and all of that stuff in just a moment. We do have a lot of people on this class, so welcome. I'm so glad you guys are here. This is going to be a great year in real estate. It has already been a very busy January and February. Compared to what we think of as the winter season, we've had a very busy winter season. This is also an election year, a crazy election year. So real estate in general is very interesting during election years. And regardless of anything that you hear in the news or anything going on, just remember your focus is on helping individuals. And shelter is a basic human need. So people need a roof over their head. They need a place to call home, regardless of what's going on in the world, regardless of politics, regardless of economics. People end up reprioritizing their time, energy, effort, and finances to make sure they have a home. So keep that in mind and don't get wigged out by the news or any national level reports or even state level reports, and just stay focused on how you can bless others with your real estate license. So all of that being said, let's dive in. All right. Again, 2024 GAR Contract Dissection, GREC course number 77063. I am the instructor. Please feel free to write down my email address should you have any questions. This course is sponsored by Maximum One Realty Companies, which you can find out information at keepmorecommission.com. Handouts will be available after class. They're not there yet. If you go to eagentweb.com, click on training videos, and then scroll through the page, and you'll find this class and the handouts. Again, they are not there yet, but will be. Notice to students, again, the school is school number 6915. We have to renew at the end of 2026. This is a virtual remote broadcast of an approved in-class course, 3 hours in duration for CE credit. You can take this class as often as you would like, but you'll only get 3 hours CE credit for it once every 12 months. No homework and no written exam. So the way we do attendance is via the chat function. So you must be on time and present for all remote virtual broadcast instruction hours in order to get credit. If you've already done so, you don't need to do it again. But if you have not done so, oh, great, thank you. I am going to ask you 3 times to type in your name, your license number, your email address, and your phone number. We need contact information for you because in running this school and teaching classes for several years, we have found that a lot of agents don't remember their license number or transpose numbers or something like that. So we need to be able to get in touch with you to make sure that you get the CE credit for the class for your attendance. So that's why we ask for contact information. So I'm going to ask you to do that 3 times at the beginning of class, when we come back from break, and right before you leave. Again, we have to demonstrate to GREC that you actually were in attendance the entire class time and didn't just turn on the computer, walk away for 3 hours and come back. But why would you? Likewise, throughout the course of the class, I will ask some questions and I'll prompt you to go ahead and put your answer in the chat. Even if I go on with the answer, please go ahead and type in your answer in the chat. Again, as just a means to demonstrate that you were actually in class and paying attention, because we keep records of the chat as well as the attendance. And there is no recruiting. If so, contact myself. Heidi Kelly is the coordinator of our school, or GREC themselves. I see a lot of old friends, so good to see everybody. And I see a lot of new faces, so welcome. If this is your first time taking a class through our school, the Real Estate Academy of America, we welcome you to take, we host several other classes, and that is where you can get the schedule. If this is your first time taking a class with me, I hope you'll take another one of my classes. I teach license law, all kinds of contracts classes, including the RE forms, and I teach the ethics class. So, but we host a variety of other classes. Check them out. We are in the process of getting a page done on our website so that the handouts will be available there. It'll just make it much more cohesive and much easier to get everything in one place. But in the meantime, that's where your handouts are available. One person said they are already there. I couldn't find them when I looked this morning, but I'll look again. I'll make sure after class they are there. And again, today's class, we're just going to focus on the purchase and sale agreement, the loan exhibits, and especially dealing with the TNR. No, I can't share the handouts in the class. There's too many of them. Can I? I'll look at that at the break and see if I can. Good question. And these are the other exhibit or forms that this class touches on, but the primary focus is on the contract. In the handouts also, I do have bonus material. You've always heard, and way back in pre-license, not so far back for a couple of you, but way back for some of you, we learned what ministerial acts are. So I have a handout that actually defines and specifies what you can do when working with the public as a customer, what constitutes a ministerial act versus a real estate related act that you, well, it's all real estate, but versus an act, things that you could do when working with a public person as a client. I do have bonus material all about sellers' disclosures, real estate agents' disclosures. What are you required to disclose? What are you not required to disclose? So forth and so on. Again, additional CE classes will be offered, including brokerage agreements and other forms. All right, we are going to dive in. So generally speaking, for all contracts, for the GAR Forms Committee, they make changes based on market and practice, based on what's going on in the market and information that they get from agents and brokers regarding contract issues we come up with based on the current set of contracts. They revise the contracts at the beginning of the year, and then they typically revise the contracts sometime in May or June. Usually those mid-year revisions have things like typographical errors, grammatical errors, syntax and formatting errors, but every now and then there are some pretty substantial corrections or additions or revisions that do impact your practice as an agent. Because most of y'all only take a class at the beginning of the year, very rarely do you take a whole nother CE class on the changes that GAR makes mid-year. Based on that, the first part of this class, I am going to cover the changes that GAR made mid-year last year, May 1st of 2022, that will cover what changed the end of 2023. Some of those changes, if they were changed again in 2024, I'll breeze over because we'll address it in the 2024 changes. GAR forms are licensed and agents must pay every year to use them. How do you pay for them? Well, if you're a realtor, meaning if you belong to a local board of realtors, then Georgia Association of Realtors gets part of your dues money, as does the National Association of Realtors. So you're already paying for them by virtue of your membership to GAR. If you are not a realtor, meaning you do not belong to a local board of realtors, you can pay Georgia Association of Realtors for the license agreement to use the forms for the year. They are not to be given to the public, and you cannot just get them from your broker. If your broker is authorized to use GAR forms, but you are not, and you are in a pinch, you can get them from the co-op agent if your signature is on the signature page, or from your broker only if it is your broker's signature on that form. Why? Well, think about it. If GAR only required brokers to pay for the forms, they would lose money. Which is a bigger pile of people, the number of real estate agents in Georgia or the number of brokers in Georgia? Yes, the number of agents. Therefore, GAR, for their licensing agreement, they require each agent to pay for the forms to use them for that year. And the last thing that popped up is, what is GAR's intent? GAR's intent is to keep transactions together. If you are a realtor, GAR does have a legal helpline, and you can go online and ask a question. And usually it is Christina Chow and or Seth Weissman that will answer those legal questions. You will need your NRDS number, which you have if you are a realtor, and you can access that link from the GAR website. All right, general contract reminders, regardless of what forms you are helping your clients with a contract, whether it's the GAR forms, the RE forms, HUD forms, Fannie Mae Freddie Mac forms, an attorney written contract, an investor written contract, even a new construction contract. These are the just general contract reminders for good practice, and a lot of these are to keep you in compliance with Georgia license law. A legal description is required. In Georgia, a street address in and of itself is not enough. Think about it. How many Peachtree roads are there? More than one. Therefore, 123 Peachtree Road is not specific enough to help a closing attorney prepare the deeds to make sure that it is the actual deed being conveyed that the parties intend. So you absolutely need a legal description. Additionally, parties, your public must get a copy of every document they sign. Please make sure your closing attorneys and your brokers also get copies of all exhibits and amendments. Don't leave any blanks. If there's a blank, you're going to put NA Or if the blank is preceded by a dollar sign, you're going to put in $0 if it's zero, obviously an amount if it's a specific amount. And on a counter offer form for a blank, you're going to put in NC, which stands for no change, meaning no change from the original offer. Do not use the initials TBD or to be determined. Why? Like a lot of times we'll see initial contracts that say closing attorney to be determined or closing date to be determined. You cannot use that because it does not reflect a meeting of the minds, meaning you don't have specific agreement written down, signed by buyers and by sellers. And that is what constitutes meeting of the minds, which is required for enforceability. If a contract is subject to financing, don't leave those terms blank. Don't leave the interest rate or any of that stuff blank. That is a requirement per license law. And as an agent, do not hold earnest money at all. You must get it to the broker as soon after receipt as is practically possible. Additionally, please complete the brokerage address on the signature page. Now, GREC does not have any license laws about an address for your broker or for your where you practice, meaning you don't have to have an address on your business cards, on any of your marketing or advertising. However, please put it on the contracts for a couple of reasons. Because GREC doesn't have any license laws about this, it could be your branch office or the corporate address if you are working with a brokerage that has several offices. You'll probably want to check with your broker to see if your broker has any policies on that. But it's very important, especially for if you don't attend a closing, or if the closing attorney has to send corrections or something like that. The closing attorney is going to need to be able to contact you, and a lot of times they do mail commission checks, copies of the final closing statement, so forth and so on. So you want to make sure that your closing attorney has a place to put in the address. Additionally, per license law, make sure your license number and firm number are on every contract. Again, easy to do on the GAR forms because they have a fill in the blank. This is something to remember, however, if you are helping a client with a contract for new construction, HUD, so forth and so on. A lot of times they don't have a fill in the blank for your license number or your firm's license number. Nevertheless, it is required by Georgia license law. Additionally, you must complete the agency representation disclosures in the contract per license law. And earnest money. Y'all, please, please, please follow up with the earnest money deposit on both sides of a deal when you're representing the buyer and you are representing the seller. If the contract says whomever the holder is, and when the earnest money was supposed to have been sent to the holder, you need to follow up with that holder. Did you receive it? Did you deposit it? Did you receive it? Did you deposit it? When nothing's an issue until it's an issue. When it is, people are looking for money. And in a purchase and sale agreement, they're looking for earnest money, whether to get it back if they're a buyer or to get it as liquidated damages if they are a seller and they feel the buyer defaulted. Well, if the agents on both sides of the deal, if nobody ever followed up to see if it was sent or deposited, the public is not going to look too kindly upon you for not following up with that. And all buyer and seller signatures are required. What do I mean by that? Well, let's say you're working with a couple purchasing a home and they are both on the contract. The contract and all forms will require both of their signatures. If two people are buying a house, one signature will not suffice. And don't miss any initial spaces. And you must include contact information for customers. Additionally, limit your special stipulations. If There is before you write your own special stipulation, look in the library. GAR has a library of special stipulations that is pages and pages and pages. And typically there is already written a stipulation for an issue you need to address. Also, the RE Forms contract package is available to all agents in Georgia, and they have a special stipulation library as well. So you might want to check those out. Big thing. Do not use a special stipulation for an issue that has already been addressed somewhere else in the contract. Okay, Dana, what do you mean? Well, we know, and I'll show you in the contract where it says this, that a special stipulation supersedes an exhibit, which supersedes the contract. So what happens is, y'all thinking that you're protecting your clients, you actually potentially harm your clients by trying to protect them. Let's say you have a contract and it is subject to financing. Well, the appraisal contingency is included in the GAR financing contingency exhibits. It's the appraisal contingency in the conventional exhibit, and it is the amendatory clause paragraph in the FHA and VA loan exhibits. Wait till you see the changes GAR made for 2024 on those two exhibits. I think you'll like them. But so the appraisal contingency is already spelled out. What happens if it doesn't appraise? Timeframes, notices, rights to earnest money, termination rights. That's already in there. And then what do y'all do? Y'all will have a contract. You'll include a conventional financing contingency exhibit. Then you'll write a special stipulation that says property must appraise for sale price, period. And then I ask you, well, what happens if it doesn't? And you say, well, then the buyer can terminate, get the earnest money back. And I say, where is that written? And you say, in the exhibit. And I say, you just wrote a special stipulation that just now negated that exhibit, because that exhibit already addressed all those questions. And now you have property must appraise for sale price, but no consequences if it doesn't, no termination rights, no protection of earnest money. So do not write a special stipulation for an issue already addressed elsewhere in the contract. That's one of the biggest issues and problems we see with agents written special stipulations. All right. Now we are moving on to, again, these are the changes that GAR made mid-year last year, just so you are aware of these. Oh, yes. I've already said this. Okay. I'm confused. Apologize. The paragraph, I guess I'm still on general. No, this is the purchase and sale. Paragraph A is all the fill in the blanks. And another thing, just for practice, and this occurs a lot with agents who have been in practice for a long time. On the bottom of the contract, it says on any form, it'll say the form number and the name, and then it'll say page 1 of however many. If it has more than one page, you must send the entire document. What do I mean? Well, sometimes you guys will negotiate and you'll change, let's say you'll change sale price or closing costs or one of the fill in the blanks on the front page of the purchase and sale agreement. And what'll happen is as you're countering and going back and forth, you'll come to terms, and then you will just send that first page that has been changed. That is a no-no. We don't know if that is signed or not. So, point of practice, if you see at the bottom of a form, it says page 1 of 10, you must include all 10 pages when sending, not just a signature page or a fill-in-the-blank page. And again, legal description is required. And the closing date. You know what? I apologize. I'm confusing the other class. I'm just covering the whole contract. I'm not necessarily pointing out if there were changes made mid-year last year. I will address those if they got carried through. So I apologize. We're just diving into the contract itself. a closing date. And let me show you this. I'm going to bounce a little bit back and forth. I've got the PowerPoint and I also have the forms. So I like showing you guys in context so you can see the form. So the handouts that are included are, again, you don't have the slideshow itself, but you do have a PDF of all of the slides. So everything that you're seeing, there is that in a handout form. Additionally, in the handouts, you will have the actual 2024 GAR table of contents that has every form listed by form number, so you can glance through that. Here we are. Now we are diving into the purchase and sale. It takes my computer a minute, so let me scroll back up here and get on the same page. So again, this is the 2024 GAR, and this is the legal description. Again, you need an address, but you also need a legal description. You can either attach it as an exhibit. Typically, the exhibit would be a copy of the seller's warranty deed, or you can get the legal description from online county records, from the closing attorney, or from gsccca.org. That stands for Georgia Superior Clerk of Courts Co-op Association. That's a mouthful. That is a site of the majority of the bigger counties in Georgia. They work together, and that is one website where you can get copies of all the legal descriptions, all the liens, so forth and so on. It is a paid site. So as an agent, it would be worth your business dollars to pay for that. Or some brokers, I don't know what other brokers do, but at Maximum One companies, we do pay for that for our agents. So they have readily available access to that anytime they want. Or you can reference the deed book and the page number. That is typically, well, not typically, that is referring to the warranty deed book and the warranty page number. Now, for years and years, we have seen this last option for a legal description. Landlocked district, section, lot, block, unit, phase of blank subdivision, plat book, and page. GMD, okay, I'll ask y'all a pop quiz. When it's asking for blank district, blank section, or GMD, who knows what GMD stands for? Type it in the chat. What are the initials GMD when referring to a legal description? Type it in the chat. What do y'all think GMD stands for? Don't Google, guess. Oh, I got some of y'all. You agents who've been practicing for a long time. Anybody? Wow. Geometric mean distance. Interesting. It stands for Georgia Militia District. Isn't that wild? So Georgia obviously is one of the original 13 colonies, and at one point this state was divided, and I'm assuming obviously for legal descriptions, since it's still there, a lot of legal descriptions are divided out by what Georgia militia district they are in. So now if you ever go on Jeopardy and you get asked that question, you'll know. Now, again, the legal description, this is the least accurate legal description because most agents and most online records don't have all this complete information. You may have land lot or district or section, or you'll have subdivision, but you won't have it all. So it's a little bit tricky for a closing attorney to be able to specifically identify the parcel of land that the buyer is buying and the seller is selling. Is it helpful to put in the subdivision name? Absolutely. But either an actual copy of the warranty deed or a reference to the warranty deed book and page are typically the most accurate legal descriptions that an attorney can use. Now, one note, we have a lot of sellers right now selling assemblages of land. What is that? That means they've got several parcels, several lots that are together, and they're deeded separately, and they're selling them as one big in one big contract to, let's say, a developer, so forth and so on. If that is the case, for legal description, you're going to write C special stipulations, and you've got to put a special stipulation to let the closing attorney know that this contract is for an assemblage of multiple parcels. So you'll need to spell that out as a special stipulation, referencing the legal descriptions of each individual parcel in the special stipulations. But what I don't want you to do is put a legal description of one parcel and then add a special stip for the rest. What's going to happen? What's going to happen is the buyer is only going to buy one parcel because the closing attorney may inadvertently miss that special stipulation and not prepare deeds for all of the parcels together. All right. Let me go back to the slideshow. I just wanted to show you in context where we are. Closing date. On here where it says closing date, it says closing shall be blank, and then it goes to possession. Do not put on or before. GAR used to have that in the contracts, and they took it out. You need a specific date for a meeting of the minds. Let's say you put closing shall be on or before March 26, 2024. So the seller gets everything all ready to go. They hire movers. They have their utilities all scheduled. They've got somewhere to go as of closing March 26, 2024. And then the buyer gets their loan done, everything done. And let's say you have closing shall be on or before March 26th. The buyer comes to you on March 15th and says, guess what? I'm all ready to go. We're changing closing to March 15th. And the seller says, I don't agree. I don't have anything. I can't be out of here by March 15th. I had all my stuff ready to go and geared towards March 26th. I don't agree. The buyer says, yes, you already did agree because March 15th is before March 26th. So that's why GAR took it out. It does not demonstrate a meeting of the minds. Put a specific date. If it needs to be changed, change it by amendment. All right. Holder of the earnest money. If it is, usually it is a brokerage or a closing attorney. If it is a closing attorney, there are two additional forms that you will need. One of them, Form F510, you need that with the contract. That is an exhibit to the contract where the buyer and the seller identify the closing attorney who is going to hold the earnest money. After you go binding, then the closing attorney needs to sign Form F511. That is not an exhibit to the contract. It does not have a place for buyer and seller to sign. It only has a place for the closing attorney to agree to be the holder. If it is a cash transaction, y'all really need to talk to your clients about having one of the brokers holding the earnest money rather than the closing attorney. Let me show you what I mean. Let me briefly go to these forms. And just as a reminder, it says right here, if the holder is the closing attorney, 510 must be attached and 511 must be signed. So let me show you what those forms are. Oh, man. Shoot. Here we go. All right. Let me make this a little bigger so y'all can see it. while we're on this topic, this is the form that is the exhibit, and it says exhibit, closing attorney acting as holder of earnest money, and you identify the closing attorney. Additionally, the buyer is required to get this contract to the closing attorney within 2 business days from binding agreement date so that the closing attorney can sign Form F511. The closing attorney has 5 business days after receiving the contract to agree or not agree to be the holder. If the closing attorney does not agree, then the alternate holder here in paragraph 7 becomes the holder of the earnest money. Y'all, when you're filling this out, don't leave it blank. You listing agents, don't leave it blank. You can fill in either the buyer or the seller's broker. If it is left blank, then it is the buyer's broker. Okay, Dana, why did you say not to use this in an all-cash transaction? Well, anything you hear in a class, whether it's from me or any instructor, you want the proof of why. So this is why I am telling you guys to really have discussions with your clients in an all-cash transaction. Again, nothing's an issue until it's an issue. But let's look here. Paragraph 8, closing attorney holding earnest money in an all-cash transaction. In an all-cash transaction where the closing attorney is representing the buyer or seller, the closing attorney can hold the earnest money in other trust funds. So they can hold it, but in the event of a dispute between the parties regarding the disbursement of the funds, what does that mean? That means it doesn't go to closing. There is one of the parties terminates, and you prepare a termination and release agreement, and you say earnest money, but let's say buyer terminates for whatever reason and they want their earnest money back. If the seller does not agree and does not sign the agreement to release the earnest money back to the seller, or likewise, if the TNR is written with the earnest money going to the seller and the buyer doesn't sign it, then the earnest money is in dispute. There is a dispute between the parties regarding the disbursement of the funds. In an all-cash transaction, closing attorney is holder. Guess what? The only remedy available to the closing attorney to resolve the dispute is to interplead the funds into a court. In other words, you have just engaged the buyer and the seller in a lawsuit, and one of them is going to have a judgment, recorded judgment against them, and is going to cost them not only the earnest money, but legal fees. And it costs money to do this. The closing attorney can hold their fees out of the earnest money. If it's an all-cash transaction and one of the brokers is holding it, now a broker can do this too. If it's too legally complicated or too much money, a broker also has the option of sending it to court to let a judge decide. However, a broker in an all-cash transaction also has the ability to interpret the contract and make a decision and send out what we call the 10-day letter and disperse the money. So sometimes one of the parties will get mad and just won't sign the TNR when it's clear per the contract who gets the earnest money, but they've just now been engaged in a lawsuit. A closing attorney, if there is a loan, can do the 10-day letter also, but all cash, y'all be really careful. So this is the exhibit initialed by the buyer and the seller where you identify the closing attorney. Then the buyer has 2 days to get this form. This is GAR F511 to the closing attorney. This is not an exhibit. It's not included in part of the contract. It is a separate standalone agreement signed by the closing attorney that comes after a binding contract. It has all the same verbiage. The closing attorney agrees to fulfill the duties of holder as outlined in the purchase and sale. They have 5 days to make that decision. And you put in the contact information of the buyer and the seller. But look, the only signature on this is the closing attorney. That's why, and it's just an agreement of the closing attorney. That's why it is not an exhibit to the contract. Do most attorneys agree to hold? It depends. You would want to check with a closing attorney before you negotiate for that on the purchase and sale. If you're going to have the holder of the closing identify an attorney, you're going to want to check with them. Some closing attorneys won't hold it if it's under a certain amount of money. Some closing attorneys won't sign that form until they get the earnest money. Some closing attorneys won't hold it because they have a previous client relationship with one of the parties. So, good question. You need to ask the closing attorney. Additionally, along those same lines, whomever the holder of the earnest money is, you need to check with them on the form of funds that must be acceptable. You also want to find out the policies of the forms, what their policy is on holding personal checks, so forth and so on. What do you mean, Dana? Well, a lot of closing attorneys and brokers, if the earnest money is over, let's say $5,000, it is required to be in certified funds. And if it's over $10,000, it's required to be a wire. What if it's a personal check or a business check? Well, most closing attorneys and brokers have a policy on a time frame that they're going to hold those personal checks. 10 banking days, that's a long time. If your buyer terminates a contract and you've told your buyer, yep, your earnest money is safe, it's protected under due diligence, and they go under contract, they write a personal check for $3,000, and they terminate the contract 3 days later because they had a bad inspection, and they terminate under due diligence. Seller signs the TNR, buyer goes and finds another house. Well, seller number 2 is also going to want earnest money. And your buyer says, well, great, we'll just use the earnest money your broker's already holding. Nope. You cannot do it. If the broker's policy is to have a hold on a personal check for, let's say, 10 business days, and the buyer put in a personal check, terminated contract 1, went under contract with contract 2 within 7 days, those funds are not available to be used on contract number 2. So you're going to have to go to your buyer and say, no, I need another check for thousands and thousands of dollars. They're going to say, I thought you told me it was safe. Well, it is. So, point of practice. It is best to deal in earnest money in certified funds or a wire. Those funds can typically be acted upon within 24 to 48 banking hours, business hours. Additionally, point of practice. If earnest money is over $10,000, y'all really need it to be in the form of a wire. Why? There is an IRS tax act. It has to do with Homeland Security, that if anyone is holding over $10,000 on behalf of another person, they have to fill out an IRS form that identifies all the information. We need copies of driver's licenses, addresses, so forth and so on, that a lot of your buyers will not want to fill out. Nevertheless, we are required to do that by law. However, if over $10,000 is in the form of a wire, then the banking information suffices for that, and we don't have to fill out that IRS tax form. And I'm going to show you something else about earnest money. Well, I'll show you that when we get to, well, let me show you this. This is something new for 2024. And if you haven't taken that class, I think you guys are going to like this. Check this out. Earnest money will be paid to holder in a method of payment acceptable to holder, which we've just been discussing, of immediately available funds as follows. And then you put in the amount of earnest money. Look here, everybody. Woohoo! Remember, there used to be check boxes that said check, cash, ACH, so forth and so on. They have removed those check boxes to avoid any confusion, and it only says method acceptable to holder. Now, this first offer A, X amount of dollars as of offer date. You are only going to check this box if you are in possession of the earnest money in and of itself, or it is already on deposit with the holder. In my previous example, you were working with a buyer, your broker was holding the earnest money, that it was, let's say it was certified funds, and that contract terminated under due diligence, the seller signed it, the buyer directed the broker to continue to hold that earnest money till they found another house. You find another house, you write contract for house number 2. Your broker is already in possession of the earnest money. You're going to fill out this contract again with your broker's name, and then you're going to mark A because it is already on deposit with the holder. For anything else, typically what we see is B, X amount of dollars within so many days of binding agreement date. That's the time frame for the buyer to get the earnest money to the holder. Point of practice. If the earnest money is going to be wired to the holder, y'all need to put a little bit longer number of days from binding agreement date. We see a lot of contracts that say 3 days, 4 days, 5 days. If it's a wire, that might need to be extended out. Why? Because nobody should be emailing wire instructions to their buyers. Closing attorneys are not a lot of closing attorneys are wiring to them. Are emailing wire instructions, nor are brokers. So if it is going to be a wire, point of practice to you guys as an agent, y'all go to your brokers and pick up pick up a bunch of copies of their wire instructions, or your closing attorney, if that's who you prefer to hold it, or the clients prefer to hold it. That way, when you are in person with your buyer, you can hand them the wire instructions, and then they can go to the bank. But if the holder has to send the wire instructions via US mail, it takes a few days. So again, just consider, it's just the emails that are getting hacked. So just consider an extended number of days if it is a wire. All right, okay, let's cover just a few more tips on earnest money since we are discussing earnest money. The fill in the blanks on the purchase and sale that I just covered, that's the time frame for the buyer to remit. Remit is just a fancy word for send. Okay, before I do that, what about business days? Great question, Earl. And I'll show you in the contract, the GAR contract defines what days are. I'm just going to skip ahead and I'll show you where it is later, but I'm going to skip ahead. If it just says days, it refers to calendar days. The contract, or you guys in special stipulations, if you mean it to be a business day or a banking day, you need to write out business day or banking day. Those are defined in the GAR contract as Monday through Friday, no federal holidays. So a weekend and a federal holiday does not count as a business or banking day, but they do count as a calendar day. So great question. Okay. Again, we talked about the wire. I talked already, both agents need to follow up with the holder on the receipt and deposit of funds. You need to check on the policies of the holders. Again, many don't accept ACH. Most brokers and closing attorneys do not accept electronic money such as Zelle, Venmo, PayPal, so forth and so on. Do not accept cash as earnest money. Do not commingle funds. What does that mean? Well, let's say your buyer says, all I have is cash, or I'm not there, I can't get a check, I can't go to a bank and get certified funds. Don't say, well, just Venmo me the money and I'll write a check, or I'll go get certified funds. No, 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 no. That is a license law violation, big time. And you are going to put yourself in a very difficult position. So do not commingle funds and do not take cash. Again, earnest money and certified funds or a wire or a money order may be released faster than a personal check. Remember, your buyers can stop payments on personal checks and they can rescind an ACH payment. If you guys are working with your public buyers and you are not going to be in possession of the earnest money to take to the holder. They are going to drop it off or stick it in the mail to the holder. Please, 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 I beg you as a broker, please make sure in the envelope that your buyer is going to get to the holder with their earnest money, they've got to put a note that includes the property address and the agent's name. I can't tell you how many times we'll get in the mail a check and it says payable to the company, thousands and thousands of dollars, and in the memo line it says earnest money. Well, the address on the check, if it's a personal check, if it's a certified check, it doesn't have anything, it'll be the address where they live now. Most brokers hold their files in terms of address. We can look them up by address or by agent. We typically can't search, or very difficult to search, our files by buyers and sellers' names. So please instruct your buyers to identify earnest money for what property and who is their agent. And again, I already addressed, if earnest money is over $10,000, the holder, even closing attorneys, by the IRS, we are required to complete Form 8300 based on the Homeland Security Act. So please wire. Earnest money is liquidated damages is the only remedy for the seller if a buyer defaults, and it is not required for a binding contract. It is not the consideration. It is not required. It's just good faith money. Additionally, again, I've harped on this enough. Both sides of the deal, it is their responsibility to follow up with the holder for the receipt and the deposit, because potentially both parties have contractual rights to those funds. Find out, did the agent deliver it to the holder? Did the buyer mail it in? So forth and so on. What address? What name on the check? What memo? Again, I've already addressed these issues. Just be good stewards of the money. All right, moving along to due diligence. Do not put in 0 days. I know some of you guys, if there is a highly competitive property and you want to make your buyer's offer very competitive, that you want to put in 0 days to try and get the seller to take your buyer's offer rather than somebody else's. You guys, in the heat of the moment, it is very tricky, and a buyer might think that's a good idea, and then they go home and sleep on it, and they're like, whoo, we just got carried away with everything. We don't really want this house. Well, they can't terminate under due diligence, and you've just lost them the earnest money. And another thing, y'all, just because if there's earnest money in a contract, just because the buyer hasn't yet sent it to the holder, it is still part of the contract. They're still legally liable for that money. So for example, let's say they put in $5,000 earnest money. They wrote the contract for $5,000 earnest money. You put in 0 days due diligence. You go binding. They sleep on it, and then tomorrow they wake up and they're like, woo, we slept on it. We decided we're going to still look a little bit. Let's terminate this contract and buy another house. Well, you can't terminate them. They'll lose the earnest money. And they're like, no problem, we haven't sent it in yet. Guess what? They're legally liable, and they can be sued by the seller and by the brokers for that earnest money for default of the contract. So at least give 1 day to sleep on it, even if you're trying to make them competitive. The due diligence period basically creates a mini option contract within the broader context of the purchase and sale. What does that mean? That means the seller gives the buyer so many days to the option to terminate the contract for under no penalty. That's why you have this $10 consideration where it says, Option payment for due diligence period. In consideration of the seller granting the buyer the option to terminate, the buyer has paid the seller $10 non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. That money does not change hands. This next section, paragraph 2, we have not seen this used in years, since really crazy, hyper competitive market. This is additional option money, additional to the $10, not additional to earnest money. It's additional to the $10 that the buyer would pay directly to the seller to, again, make their offer more competitive. But it's non-refundable and it goes directly from buyer to seller. I very seldom see this used. I haven't seen it in a long time. That's what all that is. All right. We're going to talk a little bit more about due diligence when you get to paragraph B. Now, at the bottom of the purchase and sale agreement on paragraph A, page A, paragraph A10, you have the brokerage relationships. And again, this is the buyer's broker, and you write out the firm, seller's broker, the firm, representing the buyer as a client, customer, dual agent, or designated agent. If it is a designated agent, that is the only time you fill in the name of the agent working with the buyer. And the same thing on the seller side. Seller's broker is the firm. Are they working with the seller as a client, a customer, dual agent, or designated agent? A lot of times we see a lot of new licensees that will have ABC firm working with the buyer, XYZ firm working with the seller, and they'll put the agent's names. You don't do that. This is just for designated agency. Everybody will see the separate agents' names on the signature page. And I'm not going to take the time to go over this, but this is in the handouts, or you can take out your cell phone and take a copy of this slide. This defines what single agency is, dual agency, designated agency. And just as a note, you can have both sides of a contract and it not be dual agency. That would mean only the seller or only the buyer has signed a brokerage agreement, but you are the only agent involved. That's not dual agency, but it is both sides. It can be tricky, and you need to check with your broker's policy to see if your broker allows it. Then towards the bottom, you have material relationship disclosure. This is where you disclose relationship between the principal is the buyer or the seller, and the agent or the broker. Regardless if you're working with the principal as a client or a customer, you still need to disclose the material relationship. These are family, friends, business partners. The one that most agents miss are past clients. So you could work with a past client, somebody you've worked with in the past previously, to help them buy or sell a house. And in this contract, you could, let's say you're working with them as a customer or a client, it doesn't matter. That is still a material relationship that you should disclose, that the buyer is a past client. And that's, again, a material relationship that a lot of agents miss. Now let's move on to paragraph B. So let's look at this. Let's see if there's anything else. Again, I skipped this part. If the property or any part of the property was built prior to 1978, you absolutely are required by the EPA to include the lead-based paint exhibit, which is the disclosures of the seller's knowledge of lead-based paint. And you buyer's agents, your buyers are required to have the EPA lead-based paint pamphlet that you can get from the GAR contract package, or if you go to epa.gov, you can get it there as well. And time limit of offer, just while we're here, I'm getting ready to do another video on this. I have a YouTube channel, Real Estate Made Crystal Clear, where I do video tips on all of these items in depth, and just had an issue I had to help an agent with yesterday on the time limit of the offer. So basically what happened is um is the buyer wrote an offer and they put a time limit of 3 o'clock yesterday. Well, the seller made a counter offer at 7 p.m. yesterday, and the buyer's agent had a cow and said, "You can't do that. You can't do that. The time limit's expired. The time limit's expired." Well, no, the time limit, and it's spelled out in the definition in paragraph B. The time limit is the time frame for a seller. If it's an initial offer, for the seller to accept the offer with no changes. Well, the seller made a counter offer. They changed the price and closing date and some other terms. A seller could make a counter offer anytime because they're not accepting it without changes. A seller can make a counter offer before the time limit, a few hours after the time limit. Seller can make a counter offer days after the time limit. If there's a counter offer, it doesn't matter. That's just the time frame. It's not a time frame for the other party to respond. It is just the time frame for the party to accept the offer with no changes. So that's from an initial offer to a seller, or if the seller makes a counter offer and puts a time limit on it, that would be for the buyer to accept it with no changes. And then your buyers and sellers initial here. Go back over number 10. Again, you just put, if you're working with your party as a client, if you're working with your party as a client, that means you have signed a brokerage agreement. If you're working with your buyer as a client, they have already signed a buyer brokerage agreement. If you're working with the seller as a client, they have already signed a seller brokerage agreement. If you're working with your buyer, by default, your public works with your broker as a customer. So by default, they are all customers until they sign a brokerage agreement, and that makes them a client. If they are a client, then you have to look at dual or designated agency as well. Dual agency, one broker, one agent working with both buyer and seller who have signed brokerage agreements. Designated agency, one broker, two agents, and the buyer and seller have signed brokerage agreements with your broker. All right. Now we're going to get to paragraph B, which is all the legalese or what the buyers and sellers have agreed to. So, you guys, especially in light of everything that is going on right now, this is a great, I think, point of practice for you as an agent. A lot of times when you are in the field helping a buyer write an offer or going over a can you add a time limit for a counter offer? Yes, there is a fill in the blank space for a time limit on a counter offer as well. A lot of times you'll just go over the fill in the blanks, but you won't go over the rest of the contract. I highly encourage you, the first time you are meeting with a buyer or a seller, whether they are going to be a client or a customer, point of practice, pull out a blank purchase and sale agreement, loan contingency exhibits, community association disclosures, so forth and so on. Write a big diagonal line from the lower left corner to the upper right corner and write sample on it. Get this, because you don't want them to have a blank purchase and sale agreement to use for themselves. That's why you're going to do that. Send this to your buyers and your sellers. Tell them, look, I want you guys to review this contract, go through everything. Let me know if you have any questions, because when we get an offer or when we write an offer, you're going to be excited and we're going to talk about the actual dollars and time frames and so forth and so on. But I want you right now to go through and understand what it is that you are promising to do, what your obligations are, and what your consequences are if you don't meet those obligations. So please ask them to go through that and be familiar with it. Will they read it? I don't know. Are you better protected as an agent if you can demonstrate you did this Absolutely. Is this really good customer service? Absolutely. All right. So the first thing we talk about is the warranty. What kind of title is being conveyed? Well, good and marketable title, and that is defined here as good and marketable is whatever the title insurance company will insure at its regular rates, subject only to standard exceptions. So this doesn't mean insurable. It just has to do with the amount of premium that the buyer has to pay for the title insurance. And it's by limited warranty deed. Now, this is a really important part here too with leases. We have a lot of sellers selling properties and they've got a lease in there. They've got a tenant in there. This part says buyer must assume any leases included or referenced in the contract. Buyer assumes lease seller's responsibilities in any leases specified in the agreement. So, you listing agents, if you are helping a seller and they have a tenant in there, even if the tenant is supposed to move out prior to closing, you absolutely need to reference the lease in the contract, because not all tenants move out when they say they're going to move out. If the tenant doesn't move out and you reference the lease or put a copy of the lease as an exhibit in the purchase and sale agreement, the buyer is still obligated to close on the contract. And now it is the buyer's responsibility to go and file eviction on the tenant. But again, so the you buyer's agents, if your buyers are buying a property and there's somebody living there, y'all need to address this, because the buyers can't just terminate a contract if the tenant hasn't vacated the contract, unless that was spelled out and agreed to in the purchase and sale agreement. I'm just pointing out to you, this is all spelled out here in paragraph 1A of the contract. And then under title objections, this is another thing. You agents, you'll get an email or a phone call from your closing attorney that says, hey, there's a problem with the title. Well, buyer does potentially have termination rights, but not automatically. Agent to agent communication is not binding upon the buyer and the seller. You must do everything in writing with signatures from your buyers and your sellers. So this title objection thing, if you need to protect your buyer and their earnest money to terminate a contract if there's title issues, this is what it says. Buyer may examine the title. Obviously, we know it's the closing attorney doing that, but they can give the information to the buyer. And if there is an objection, then and a survey, make sure you buyer's agents, make sure you're letting your buyers know they probably should have a survey. Do they get them done? A lot of times not, but you need to bring this up, especially during their due diligence period. But anyway, buyer may examine title and obtain a survey and furnish seller with a written statement of title objections at or prior to closing. If the seller fails to or is unable to satisfy valid title objections at or prior to closing, or any unilateral extension thereof, which would prevent the seller from conveying good and marketable title, buyer may, among its many remedies, may terminate the contract without penalty with notice. So this is what I'm saying. You buyer's agents, your buyer can't just terminate if there's a title issue. You have to fulfill the terms of the contract. You have to demonstrate that the buyer sent the seller a written statement of what those objections were. And then if the seller can't satisfy those objections before closing or unilateral extension, then your buyer sends the TNR, but and they'll get their earnest money back. But if they did not put in writing, signed by the buyer, closing attorney to agent communication does not fulfill the terms of the contract, because your closing attorneys are not parties to the contract and you as agents are not parties to the contract. You need to do this on a form signed by your buyers and sellers, and use the form GAR F816. It is a notice form. Sign it by the buyer to protect their earnest money. Closing costs. Just had an issue with this too. Seller shall make any reference seller's monetary contributions which the buyer may use towards to pay any cost or expense of the buyer related to this transaction, including any commission obligations of the buyer. I'll come back to that in just a second. And it says, buyer acknowledges that buyer's mortgage lender may not allow seller's monetary contributions or full amount thereof. Any unused portion remains the property of the seller. What does that mean? So here's the issue we had yesterday. We had a buyer, all cash transaction. They negotiated a purchase and sale agreement. I don't remember the sale price, a couple $100,000. The seller agreed to contribute $10,000 to the buyer's closing costs. Well, guess what? It's an all cash transaction. The closing costs, there weren't prepaids and escrows. The closing costs were basically attorney's fees and title search. No way. They were just a few $100, not $10,000. So they got the preliminary HUD, and the rest of that $10,000 contribution was now credited back on the seller side of the preliminary HUD. Buyer's agent had a cow. Buyer had a cow. Said, "Where's that $10,000 the seller was going to give me?" And the seller said, "It's only for closing costs," and it clearly states unused portion shall remain property of the seller. And they tried to negotiate for the seller to come down in sale price or something. The seller wouldn't do it. So I don't know if the seller's agent knew that and it was just tricky, or they just came with that afterwards. But y'all, in the GAR contract, remember, any unused portion shall remain property of the seller. Now, what does it mean when it says including commission obligations of the buyer? Well, let's say you've signed a buyer brokerage agreement with a buyer, and in the commission portion of the buyer brokerage agreement, let's just say that you've put, for example, I'm really hesitant to put amounts because of everything going on. So I'll do the traditional apples. Let's say that the buyer agreed to that your services were worth 3 apples. And let's say the house they ended up buying, the listing broker and or seller were only going to pay your broker 2 apples. So the buyer agreed to pay you 3 apples for your services. You're only getting compensated from the selling side, from the listing side, 2 apples. So at this point, at closing, the buyer is obligated to pay your broker 1 additional apple. What this is talking about regarding closing costs, if the seller agreed to pay 10 apples to the buyer and closing costs were 9 apples, instead of that 1 apple going back to the seller, the buyer, because now they have a commission obligation, the buyer can now use that leftover 1 apple from the seller to pay their commission obligations to the buyer's broker. That's what that means. It's not, now if you wrote 3 apples in the buyer brokerage agreement and the listing side is paying you 3 apples, then there is no buyer commission obligation. So any leftover money would go back to the seller. I hope that's clear in Apple terminology. And then the seller pays the fee for the closing attorney if there's any cost to cure any clouds on title, if there's fees for not attending the closing, and payoffs and so forth and so on. Buyer also has to pay Georgia property transfer tax, cost to search the title, prepare all the deeds, and any other costs and fees and charges to close the transaction, and all other title fees and post-closing costs. So again, you guys, this is why it's really important to get these documents into the hands of your buyers and sellers so they see it doesn't come, they're not sitting at the closing table saying, "Why do I have to pay that? Why do I have to pay that? I don't agree." Well, guess what? You already did agree when you signed the purchase and sale agreement. And then prorations, this has to do with property taxes. And basically, the closing attorney bases the taxes at closing based on the information available at the time. If the tax bills are not out yet, then the closing attorney, the only information they have to go on was last year's tax bill. The current year, the taxes could increase. If the closing attorney doesn't have that information yet because the tax bills haven't come out yet, there could be a difference, a shortage owed to the county and or city. Buyer and seller agree to prorate those differences among themselves. And then closing date, we've already talked about having a specific closing date, but let's talk a little bit about the unilateral extension of the closing date. So, first of all, this is not Georgia law. I have a lot of agents that mistakenly think it's Georgia law to have the right to unilaterally extend a closing date for 8 days. What do you mean, Dana? We've had some agents that their buyers were binding on a contract for new construction on an Atlanta Builders Association new construction contract. And for whatever reason, they had to delay it, and they pulled out a GAR 8-day unilateral notice to extend. Well, you can't do that. And they said, yes, we can. We need to extend. It's for a lender issue. Well, that is just a GAR contract provision. It's not Georgia law. So what does GAR say? GAR says that either party, buyer or seller, has the right to extend a contract for 8 days unilaterally. Unilaterally means it only needs one signature. You have to send the notice to extend before the current closing date, but those 8 days are counted from the closing date, not from the date of the notice. There are only specific reasons you can do it, and they are outlined here. If the mortgage lender, if it's still tied up in underwriting, as long as that delay is not caused by the buyer, if the closing attorney can't get you scheduled, or there's issues with the title, and the closing attorney can't close it, or if the lender hasn't sent out those TRID financial disclosures. The other thing is it can only be used one time per contract, not one time per side, one time per contract, and anybody can use it for any of those reasons. You don't have to stay on your side of the tracks. What do I mean? Let's say you get notice that the file is still hung up in underwriting, but the seller wants to close with this buyer. Even though it is a mortgage issue, a buyer issue, the seller can use the 8-day unilateral notice, even if it's for a buyer issue. Likewise, if there's a title issue, as long as it's not a lien on title that can be paid off by money, and that's spelled out there, and the buyer wants the house, the buyer can use the 8-day unilateral extension, even if it is a title issue. Now, I have here, never schedule a closing on Friday in the GAR contract due to this provision. Wait for a couple of slides. I'm just a little tickler as to why that is the case. So again, I just went over these. These are the reasons to use the 8-day unilateral. Again, I just said it is not a law. It's just a Georgia contract provision. Now, remember, your parties, your buyers and sellers, they can extend the contract as many times as they want via amendment, as long as they both agree. And so you would use amendment to change closing and possession date, GAR F716. Now, why do I say never close on a Friday? Well, this paragraph later on in the GAR purchase and sale agreement, paragraph C4F, extension of deadlines, this is what it says. No time deadline under this agreement shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday, except for the date of closing. Let's see if I have a calendar. All right. So okay, so let me go back. What does this mean? That means if your due diligence period ends on a Sunday, it ends on a Sunday. If your financing contingency, If your financing contingency ends on a federal holiday, President's Day, it ends on President's Day. If your closing date, however, falls on a Saturday, Sunday, or as of Monday of this week, President's Day, that is a federal holiday. No deadline shall be extended if it falls on one of those. So your regular contingency timeframes would end on those days, except for the date of closing. What does that mean? That means if for whatever reason your closing date's on a Saturday, Sunday, or federal holiday, it automatically gets moved to the next business day without anything needing to be signed. Okay? Now, what does that have to do with this 8-day unilateral extension? So, let's say 8 days can magically turn into 10 or 11 days. That is a long time for one of the parties to be held into the contract against their will. Why do I say against their will? If they had agreed to it, you guys would have done it by an amendment. Unilateral extension is only signed by one party. So it is a last-ditch effort that because the other party doesn't agree, but one party wants to stay in contract. So if your original closing date is here, Friday, January 5th, and you use the 8-day unilateral, well, let's count 8 days. 1, 2, 3, 4, 5, 6, 7, 8. We just read by extension of deadlines. We can't close on a Saturday, moves to the next day. Oops. Next day is Sunday, can't close then. What about the next day? Oops. Next day is Monday. That's Martin Luther King Jr. Day. That's a federal holiday. Can't close then. The next closing date is the 16th. Original closing date was the 5th. By virtue of the 8-day unilateral extension, we are now closing on the 16th. That is a long time. That can only happen when your original closing date is on a Friday. If our original closing date was on a Thursday and you use the 8-day, 8 days is 1, 2, 3, 4, 5, 6, 7. We would close on Friday the 12th. So again, point of practice. If you go binding under a GAR contract, never have your closing date on a Friday because you run this risk. All right. Moving along to keys and openers. At closing, seller shall provide all keys, door openers. They've added this for this. Actually, I think they added this at the end of 2023. Fobs, access cards, codes, and other similar equipment allowing access to the property, the community, and community amenities. In the event the seller is required to return those to a third party, you have to provide instructions. What does that mean? That means there are some HOAs or management companies where the homeowner gets a key fob or a card or credit card or whatever to access, let's say, the swimming pool or the clubhouse. Well, when that seller sells, they have to turn that key fob, that card back into the HOA. So if that's the situation, the seller can't just give it to the buyer. They have to turn it back into the HOA, but they have to give instructions to the buyer whom to contact to get that information. And then this is brand new in 2024, this whole new paragraph on devices and fixtures. You guys, we have run into so many issues with this over the past couple of years, and I'm so excited that GAR added this in for 2024. All of our sellers have not all of them, but have these really cool technology things. They've got Ring doorbells, and they've got garage doors that open remotely by a third-party app. They've got all these remote devices and gizmos and gadgets that operate their home remotely or by an app or by a computer. And so what this says is, at closing, the seller needs to provide all those logins and codes and controllers to the buyer and reset them back to factory standards, factory default settings. Additionally, the seller has to terminate their administrative access and notify, let's say there's a third-party monitoring system for an alarm system or something. You have to notify the buyer of, again, whom to contact, who else has access to their house. point of practice, you buyers agents, y'all need to instruct your buyers, or at least disclose to your buyers, suggest to your buyers that they have the house rekeyed. How many of y'all have keys to your own home buried out in your front yard for your children in case they lose their keys? Or neighbors, trusted neighbors across the street have copies of keys to your house in case they need to get in while you're out of town, or help a child get in, or something like that. So sellers don't always know where who has access to their home if they've lived there a certain number of years. So it's always a good idea for buyers to have the whole property rekeyed. And then closing law firm. This says the buyer shall have the right to select the closing attorney. All right, pop quiz. Who does the closing attorney represent in a transaction? Type it in the chat. Buyer, lender, buyer, buyer. Lender if a loan, seller, seller, lender. All right. If there is a loan, the closing attorney, follow the money. The closing attorney represents the mortgage lender if there is a loan. Now, if there is not a loan, generally speaking, what this says up here, this says the buyer has the right to select the closing attorney. Now, this says here, if the buyer does not obtain mortgage financing, in other words, they're paying cash or not getting mortgage, the closing attorney shall represent the buyer. Now, agents, make sure your buyers do not think they have legal representation should there be a dispute. That is not what it means at all. I don't know of any attorney that's going to represent the public in a dispute for free. So it does not mean that they represent the buyer in a dispute. What does it mean? Well, it's spelled out here. It says the closing attorney shall represent the buyer in preparing closing documents, clearing title, conducting the closing, dispersing the funds, recording the deeds, issuing title insurance policy. Other than those services specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, including but not limited to certifying or warranting title of the property for the buyer, except pursuant to a separate engagement agreement signed by the closing attorney and the buyer. Now, there are, in Georgia, let's see if I have this on the next slide. Here we go. Georgia requires the closing attorney at closing disclose which party they represent. So it's disclosed in the GAR purchase and sale agreement right there. That's why it says the closing attorney shall represent the buyer. Again, not in a dispute, but with respect to all of that stuff itemized above. That's to be in compliance with Georgia law. However, most closing attorneys have their own documents. Additionally, there are some closing attorneys that have a client-attorney relationship with sellers, specifically a lot of new construction sellers, but other sellers as well. So there are times, even in a GAR purchase and sale agreement, where the closing attorney in a cash transaction would represent the seller and not the buyer. Again, it is just in terms of these issues. Any other legal representation, what we typically think of as a dispute issue, a party must sign a separate agreement. In other words, they need to go hire an attorney. So I just wanted to point that out to you. Now, earnest money, we had a really good discussion about that earlier, so I'm just briefly going to touch on this section. It says the earnest money will be paid in a method of payment acceptable to the holder, and the holder has the right to charge the buyer for any costs associated with receiving earnest money. Such charges shall be collected separately from the earnest money. Now, the fill in the blank has the time frame for the buyer to send the earnest money to the holder, but per the GAR contract, the holder now has 5 banking days to actually, from receipt of the contract and the earnest money, to actually deposit the earnest money. So that's what it says. Earnest money will be deposited into the holder's account not later than 5 banking days after receipt of the contract or 5 banking days after it's received. So because not all brokers are open 24/7, 7 days, 24 hours, 7 days a week, holders have 5 banking days. So there is a little bit of leeway there. Now, and the holder, here's what I talked about. I gave an example of a buyer terminating. Regardless of the source of the funds, the holder shall not return the earnest money until the check or ACH has cleared the account on which the check was written. And again, most of your holders, attorneys, and brokers have policies on that. Typically, bank checks, money orders, wires, we know they've cleared within 24 to 48 banking hours. Personal checks typically take a little bit longer. So that is, for brokers, that's license law, and it's spelled out here in the contract. Now, let's say the buyer sends the earnest money to the holder makes the deposit, and it bounces from the bank, or the bank doesn't honor the money for whatever reason. The holder then has to give notice to the buyer and the seller saying, y'all, in essence, the purchase and sale agreement is a receipt from the holder that I have the money and I've deposited the money if I'm the holder. So I get the money I deposited, it bounces from the bank doesn't honor it. I now am going to say, whoa, I am no longer in possession of these funds. I never got these funds. The bank didn't honor these funds. So the holder sends notice to the buyer and seller saying, there is no money on deposit on behalf of the buyer for this contract. Then the buyer has 3 banking days from the date of that notice to cure the default. The buyer's in default, and they have to make good on the money. If the buyer doesn't do so, the seller then has 7 days after that time frame to either say, okay, buyer, we're going to go ahead and go to closing. There's just no earnest money in the deal, or the seller would terminate the contract. Now, if the seller terminates if holder sends notice, I don't have earnest money, buyer doesn't make good on the money, and seller terminates, guess what? There's no earnest money for liquidated damages. They're terminating because there is no earnest money and the buyer didn't make good on it. What's the benefit to the seller? The seller can go back on the market and sell it to somebody else. That's what I just talked about. If the seller does not terminate and wants to go to closing, typically that happens in a lot of cash transactions or quick closings. That's fine. Again, earnest money is not required, but you need to let a lender know, if any, and you need to make sure the closing attorney knows so that the buyer does not get credit for the earnest money on the settlement statement. All right. Continuing on with earnest money. Let's finish this section, and then we'll take a break. Continuing on with the earnest money. Buyer is entitled to the earnest money. This is, okay, let me do this. This is all spelled out here. I think I've got it in the slides. Yep. If there's no issues, then the buyer gets the earnest money if they never go under contract. If they don't meet an agreed upon contingency and send notice of termination before the end of that, then they're entitled to the earnest money back. Or if the seller terminates by default or upon closing, they get a credit for that on the closing statement. Now, it also says here, disbursement of earnest. So that's when the buyer's entitled to it. Now, disbursement of earnest money. So it says that holder may disperse earnest money if it closes, if there is a subsequent written agreement by the buyer and the seller, or a court order. So what is the subsequent written agreement by the buyer and the seller? Well, that's what we refer to as the TNR, termination and release. That's not what it says on the form, but that's just jargon-wise what we call it, T and R. It is GAR Form F522, unilateral notice to terminate and proposed agreement to disperse earnest money. Now, let me show you back here. This is brand new for 2024. So if there's a T&R, completely signed T&R, then the holder disperses the earnest money based on how the buyer and the seller agreed for them to disperse the earnest money. If you do a T&R and one party terminates and the other party does not agree, one of the things that the holder can do is what's called a 10-day letter. And it's all spelled out here. The holder may disperse upon reasonable interpretation of the contract. So the holder goes through the contract, finds out why it terminated. The termination notice, was it sent based on an unexpired contingency? Did the party terminating default? So forth and so on. The holder sends their notice saying, based on my interpretation of the contract, this is the party I'm giving the earnest money to, and this is why. I can't disperse it immediately. I have to wait at least 10 days before dispersing the earnest money to give the party not getting the earnest money the opportunity to make an objection. That's why we call it the 10-day letter, because I have to wait at least 10 days. Now, this is brand new for 2024. No interpretation shall be made by the holder dividing the earnest money between buyer and seller, and any party, real estate licensee, or other person having knowledge of or interest to the disbursement may object to or provide information regarding the disbursement. So what does all that mean? That means well, first of all, just so you know, those funds are tied up for the buyer. The buyer can't use them towards another contract. Any party with an interest in the funds may object. So sometimes I don't get an objection from the actual buyer or the seller, but the agents, you guys as agents, y'all know more what happened, communication. Y'all might have copies of amendments that were signed that the holder didn't get, so forth and so on. Or a lender could have information, or a closing attorney could have information. So as holder, in terms of interpreting the contract and making a decision, I am allowed input from other parties, not just the buyer and the seller. Additionally, this says new in 2024, the holder may not split up the earnest money. There are a lot of times, I can't tell you, when I would love to split the earnest money, $5,000, seller did a little wonky, buyer did a little wonky. I would love to give $2,500 to the seller, $2,500 to the buyer, or $3,000 to the buyer, $2,000 to the seller. As the holder of the earnest money, I am entrusted with those funds in total. I cannot split up that money. However, the buyers and sellers can do that. So sometimes if there's a little bit of issues on both sides, as agents, y'all might want to have discussions with your buyers and sellers, and do on the release portion of the T&R, have them say, okay, holder, I want you to disperse $2,500 to the seller and $2,500 to the buyer. I can't do that, but they can do that. Or again, if it's too legally complicated or too much money, just like we discussed with the closing attorney, a broker holder also can say, I'm a broker, I'm not an attorney. This is getting into a lot of legally very complicated issues. I'm going to interplead it and let a judge decide. Again, I have to hire an attorney to do that. I can take my fees out of the earnest money, and the loser has to pay the winner's legal fees and the amount of money that I had to take out to do that. Or I can disperse the money if I get a court order to do that. And let me show you back here too. Now, as long as there's no outright fraud, there is a hold harmless. Here's where it talks about the loser pays the winner's attorney's fees, court costs, and amount deducted by holder. Here is the hold harmless. All parties, buyers and sellers, hereby covenant and agree to indemnify and hold the holder harmless from and against claims, injuries, suits, and damages arising out of their performance by the holder of its duties. And not sue the holder for any decision. What does that mean? Okay, couple things. First of all, it says they agree to not sue the holder for any decision of the holder to disperse the earnest money in accordance with this agreement. Whenever you see in a contract it says they can't sue, a buyer and a seller, anybody can sue anybody for anything. But what this does is if a holder gets sued for acting as holder and doing a 10-day letter interpreting the contract and dispersing the earnest money, the holder's attorney would argue, look, buyer and seller, you agreed to not sue. So are they going to sue? They might. This just gives the attorneys the legal groundwork to argue to win that case in front of a judge. A judge can decide anything, but just because something says it can't sue, they can sue. Again, this is just legal groundwork. So I just wanted to point that out to your attention. And went over that. All right. Let's go ahead and take a break, and then we will finish up with the purchase and sale agreement, and I'll go a little bit faster, and we will get to the financing exhibits and then knock out the rest. So I have 11:11. Let's take a 15-minute break. So let's come back at approximately 11:26. All right, so continuing on, we will get back. Let me share my screen again. All right. Everybody is back, so I'm glad for that. Get all this out of the way. All right. So continuing on, we are still in the purchase and sale agreement. Again, this is a deep dive. I hope everybody is learning something or relearning something that they had forgotten with respect to the purchase and sale agreement. But we are continuing on lead-based paint. And again, I had already talked about at the beginning, 1978 is your magical year. Now, not only if the house was built prior to 78, but if anything in the house was painted potentially prior to 1978. In other words, an antique mantelpiece. Nowadays, antique to me doesn't mean prior to 78, but I suppose nowadays antique could mean prior to 78. But if anything in the house, especially with, HGTV and reclaimed barn wood and things like that, we just have to disclose that to buyers so that they have the opportunity to investigate for a lead-based paint should they wish to evaluate for lead-based paint. Again, agents, if the house itself was built prior to 78, or again, anything in there prior to 78, before offer, your buyers have to have that lead-based paint disclosure form and the lead-based paint pamphlet. This is per the EPA. What does that mean? That means you listing agents, when you list a house that was built prior to 78 or something in there, y'all need to have your sellers complete the lead-based paint disclosure, which is actually now included in the seller brokerage agreement that they're required to do that at time of listing, and make that form available to any and all potential buyers. And then due diligence period, disclosures, repairs. So let's talk about this. I've got it all spelled out on the slides. Talking about inspection and due diligence. Again, as previously mentioned, the due diligence period is an option contract. What does that mean? That means that it is the seller giving the buyer the option to terminate the contract by sending for any or no reason and send notice of termination prior to that agreed upon negotiated time frame. There's many things a buyer is going to check out to help them make the decision, am I going to go through with it or not? And the buyer can have independent home inspections, surveys, make sure their loan's going to go through, make sure they like the commute to work, make sure it's in the right school district, make sure it's not in a flood zone, find out how much their homeowner's insurance is going to be, find out how much the HOA dues are going to be, make sure they like it. Use Google Earth and make sure there's not a nuclear power plant behind the cedar cypress trees in the backyard. Check out title, all kinds of things. Now, there are a seller, a buyer can say, okay, seller, there are some things I found and I'd love for you to address. At that point in time, a seller never has to make any repairs on a property if they don't want to. Now, if they go under contract and if it's an FHA or the buyer's getting an FHA or a VA loan, you'll see when we get to those financing exhibits what the sellers agree to do with repairs, but they don't ever have to. And but the buyer can say, look, seller, I found some things. The seller has incentive before the buyer's due diligence period. I mean, the seller chose to go under contract with this buyer. They want to go to closing. So there is some incentive on behalf of the seller to address some concerns with the property, even though they're not required to. Likewise, you sellers, you agents working with sellers, if they're selling a property as is, that's fine. A buyer's like, okay, that's just communicating to me that you have no initial intention of doing any repairs. I still have the opportunity to check out what it is that I'm buying and terminate it if I have a due diligence period. A due diligence period is only a buyer right to terminate, not a seller right to terminate. And again, the buyer can do it for any or no reasons. The buyer also has the right to inspect the property and the neighborhood, and the buyer or buyer's representatives have rights to enter the property through closing, but it's still somebody else's home, so you do have to give notice to the seller. Why through closing? Well, you want to make sure at closing that the property is in the same condition that it was at time of offer, and if any repairs had been negotiated, you want to see how they were done. The buyer agrees to hold the seller and both brokers harmless should there be any damage to the property or injuries caused by the buyer or the buyer's inspections. Buyer to repair property to condition it was prior to inspecting if there was damage done. And again, we talked about the lead-based paint. Here's a slide on on lead-based paint. And again, as I mentioned earlier, you can go to epa.gov to get copies of the lead-based paint pamphlet and the disclosure forms. They're in GAR and they are in the EPA. Seller, if the house was built prior to 78, you must allow the buyer a 10-day risk assessment for lead-based paint if they so desire. Not only the federal government, but Georgia also has a couple of resources for lead-based paint as well, the Environmental Protection Division and the Department of Community Affairs. If a buyer does have a due diligence period and they are going to terminate, they must send the termination notice. Now, there's a checkbox on there that says they're terminating based on due diligence. You don't have to give a reason. You can just put based on my contractual option to do that. And termination and release. Again, these are two separate contractual issues. I understand why the Georgia Association of Realtors has these issues on one form, but there are a lot of times I wish they were on separate forms because they are two separate contractual issues. The termination of a contract, any party can terminate. The release of the earnest money is a separate issue. The termination is unilateral, but the earnest money disbursement must be by agreement. You must have both parties' signatures. Now, the question about the release of the earnest money is, did the party that terminate, did they do it by an unexpired contractual contingency, or did they do it by default? That usually determines what happens with the earnest money, but it doesn't matter. You can still terminate by default. Oops, I've got separate spelled wrong. And again, continuing on, I'll get to the TNR forms actually in just a little bit. The seller must disclose latent material defects, even if they are selling the property as is. That's defects in the property. And if an agent is aware of the defects, you have to disclose them too. A latent or hidden material defect is a defect that could not have been discovered by a buyer by reasonable inspection, and it is very difficult to prove. Again, in the handouts, I have this extra bonus material for you that is all about seller and agent disclosures. It talks about it cites the Georgia law, the code section, what sellers have to disclose. I have a section here on stigmatized properties. As a listing broker, what you're required to disclose. You, as a Georgia licensed agent, what you must disclose regarding known latent material defects based on Beretta and the Realtor Code of Ethics. So I do have that bonus material for you. And as previously mentioned, I'll get to that in a minute. I do have this extra section bonus material for you. As I mentioned earlier, what constitutes a ministerial act? And this is directly from the Georgia Real Estate Commission's newsletter way back from 2021, but it's just a really good, I wanted to get this into your hands, just a really good example of what constitutes a ministerial act and what does not. And back to the purchase and sale agreement, just so you know where we are. It does take my computer a minute to pop up with the words, but we are in this section here under inspection and due diligence. All right. All right. And Georgia is a caveat emptor state. So again, a buyer can do all kinds of inspections. The legal burden in Georgia is on the buyer to make themselves satisfied with whatever it is they are purchasing before they exchange money for goods and services. So again, buyers should check out all of these issues. They can ask the seller to address concerns on the GAR F704 Amendment to Address Concerns. Point of practice to you guys as agents. If you are coming to the end of your due diligence period, and let's say the buyer has initiated an amendment to ask the seller to address some concerns, and the listing agent communicates with you that they are considering those things. An outstanding amendment to address concerns does not extend due diligence. So your due diligence deadline is a drop dead deadline. It only gets extended by amendment. So if it is what I call a make it or break it issue, and your buyer does not want that house, if the seller doesn't fix those issues, then you need to terminate your buyer and protect their earnest money. Again, due diligence may only be extended by an amendment. There's a form GAR F710, amendment to the due diligence period. And okay, here's a point of practice for you guys. Let's say you have a buyer and there's the buyer, let's say the utilities aren't on. Well, how do you protect your buyer's earnest money and inspection rights if the utilities aren't on? Because an inspector can't inspect, and so you're going to eat up those days. But your buyer wants the house, but they want it inspected. So a lot of times what we'll see is we'll see an agent say due diligence to begin upon buyer to turn on utilities, and due diligence to begin when buyer receives notice that seller has turned on all utilities. Well, what happens if the seller never turns them on? And you're thinking in your head right now, well, I'll just terminate under due diligence. No, you can't, because the special stipulation you wrote is due diligence to begin when the seller turns on the utilities. If they never turn them on, your buyer can't terminate because due diligence hasn't started. So I want you guys to take a screenshot of this special stipulation. Again, this is how to protect your buyer's due diligence time frame if, for example, the utilities aren't on, if the seller hasn't provided the community association disclosure, things like that. Here it is at the bottom. Due diligence to begin upon binding agreement date and extend for whatever, 10 days, 7 days, 4 days after buyer's written receipt of notice. So in my example with the utilities, it would say due diligence to begin upon binding agreement date and extend for whatever, 10 days after buyer's receipt of written notice that all utilities are on and operational. How does that work? That your due diligence, you always want your buyer's due diligence to start at binding agreement date. Because if you never get notice, if the seller never turns on the utilities, then your buyer just terminates, gets their earnest money back, and goes and finds another property. If 5 days into it, you get notice that the seller has finally turned on the utilities, well, then your buyer can then go hire an inspector and will now have 10 days from that date to have the property inspected and potentially terminate. All right, negotiated repairs. Just a quick tip on this. You guys, there is no clear answer. It would be up to a judge. The clear answer to what, Dana? Well, let's say buyer and seller go under contract and there's an amendment to address concerns and seller agrees to do repairs. You go to the final walkthrough and the seller hasn't done them. May a buyer terminate? The answer is not necessarily. If you specifically wrote a stipulation that said, should seller not complete repairs 3 days prior to closing or by closing, buyer has right to terminate contract with full refund of earnest money. If you don't write that in there, the buyer does not automatically get termination rights with return of earnest money. It would be up to a judge. Do not leave it up to a judge. Do not engage your people in a lawsuit. If repair issues also don't survive closing, so a buyer may not have grounds for suing the seller after closing. So what do? Well, you address potential issue of the seller's non-performance when you negotiate for repairs. Additionally, you're going to use the magic phrase, this provision shall survive closing, to give the buyer the groundwork to have the seller actually still be legally obligated to do those. What's the best way to do it? Well, check with your broker and your broker's policies, and it always depends on your buyers and sellers. But by far, it is much easier to negotiate financially for repairs rather than the seller doing them. Typically, the seller performing repairs is not up to the buyer standards, and the buyer, it just causes issues. So this special stipulation at the bottom is another great one to have in your bag of tricks, so to speak. At closing, from seller's proceeds, seller to pay Carpets R Us or whatever, blank amount of dollars. That way, it's handled financially. The money does not count for a concession to your buyer, so it doesn't involve the lender. And then you go to closing. The closing attorney will write a check to whatever vendor, in my example, Carpets R Us, hand that check to the buyer. Then you close. Then the buyer can call the carpet company. They can make the schedule. They'll get copies of the warranties, and they'll have the check already in hand payable to that vendor. Additionally, you could escrow funds to take care of repairs later, so forth and so on. Again, we have a bunch of special stipulations. I will include those in the handouts that are written by closing attorneys, and there are some pre-printed from the RE Forms special stipulation library, and there are a lot of repair special stipulations in the GAR library. Just check with your own broker prior to using any special stip in a contract. These are some of them, for example, authored by Amy Davis of Davis and Associates. And this is an issue where all parties agree repair work is agreed upon so many days prior to closing, and with copies of invoices. Here's the important part. Should seller not complete the work, buyer shall have the right to either immediately hire vendors of buyer's choice and have work completed at seller's expense to be paid at time of closing from seller's proceeds, or terminate. So again, I've addressed these issues, the specific wording. There's more of these, and again, you'll have access to those. All right, moving along in the contract, in the contract itself, we are now in the paragraph about brokerage relationships and what all of this section is here. So let me go back to the slides. And again, per license law, you must disclose an agency relationship you have with the public in any contract. Again, in GAR, they have fill in the blanks for you in paragraph A10. And as mentioned, public is a client when and only when they sign a brokerage agreement, either a seller brokerage agreement or a buyer brokerage agreement. It can be exclusive or non-exclusive, but the client relationship is contractually driven in Georgia. By default, the public is a customer. They're not legally required to sign anything, but it is a great idea for you to make sure your public people sign for a seller authorization to show unlisted property and for a buyer to sign agreement to work with buyer as a customer. That discloses to them their customer relationship with the with your broker. All right, and again, this is the definitions of the agency relationships. Consumer brochures. You guys, there are a lot of consumer brochures. When appropriate, please make sure to be able to demonstrate and get into your clients' and customers' hands the appropriate GAR consumer brochures. There are ones for sellers, buyers, radon, lead-based paint, agency, homeowners associations, condo, new construction, flood hazard, so forth and so on. Now, in the brokerage relationship section, continuing on, commission is earned by the brokers. It says here, commissions owing, unless otherwise specified herein, real estate commissions owing the seller's broker and buyer's broker are pursuant to separate brokerage agreements. What is that? That's what we just talked about, seller and buyer brokerage agreements. And any commissions to be paid to the brokers shall be shown on the settlement statement and collected by the closing attorney as a precondition to closing. When an agent and or a broker signs the purchase and sale agreement, they are signing, it just reflects their role regarding the agency relationship or customer relationship with the public. And it is when you sign, if your broker is designated as the holder of the earnest money, it says that the holder agrees to fulfill those terms as holder of the earnest money. So your signatures are not required for enforceability of a contract. However, there are some lenders that actually require agent and or broker signatures in order to sell the loan. We did have a contract a couple years ago that we represented the buyer. The seller's they got it negotiated with the seller. The seller's agent refused to sign the purchase and sale agreement. Their business model was such that they really just marketed the property for the seller. They refused to sign it, and the lender could not sell the loan. The buyer did end up terminating the contract under other lawful reason and did get their earnest money back because the agent failed to and refused to sign the contract. This whole disclaimer section, You guys, this section is so important and really protects you as an agent and your brokers. And it goes on to say that buyer and seller have not relied on any advice or representations of the broker other than what is included in this agreement. Brokers have no duty to determine whether the identities, this is new, of the buyer and seller are legitimate. That's new because of all the seller fraud we have going on lately with vacant land and vacant properties and land. So be extremely careful. It also says the brokers and agents have no duty to inspect the property, so forth and so on, or any matters relating to the property that could have been revealed through, in essence, the buyer's due diligence of a survey, appraisal, title search, pest control, utility bill inspection, so forth and so on. It goes on to say buyer and seller should seek independent expert advice. And it also says that agents and brokers are not responsible to monitor, supervise, or inspect for any repairs or any reviews of any reports given. And that we also have no duty to make sure that the seller has terminated any third-party administrative access to devices. That's that new section we talked about with all these cool gadgets and technology with remote access to properties. And it goes on to say any special stipulations are done. The buyer and the seller are to ensure that they understand them and that they are in their best interest. It also goes on to say that when and if a broker answers questions of a buyer, it is based on information provided by the seller. There is another GAR form, GAR F325, Broker's Information Disclosure. If you, as an agent, are asked a question about the property, probably a good idea, instead of just email to email or a phone call, to use this form where you give the question, the answer, and the source of the answer. And then, as already mentioned earlier, time limit. Again, the time limit is this offer without any changes is open for acceptance until this time. Again, it is not a time frame for the party or the agent to respond. If there is a counter offer, if any of the terms are countered, then the time limit really doesn't matter. So here's a question. Let's say there is a time limit of 3 p.m. Let's say that a buyer writes an offer to a seller and they put a time limit of 3 p.m. today. And let's say the seller doesn't change any of the terms, but they're at work and they can't get to their computers and they don't sign it until 6 p.m. tonight. Do you have a binding contract? Yes or no? Time limit was 3. Seller from the initial offer from the buyer, seller signs it at 6 and sends it back to the buyer. The answer is no. You do not have a binding contract, even though the seller did not change any of the terms. Why? The offer was only open for acceptance until 3 p.m. It was taken off the table at 6 p.m. Therefore, the seller signing it at 6 p.m., what does that make it? That makes it a counter offer. So in essence, if the seller signs it after the time limit, then it becomes a counter offer. And in essence, what you need to do is do one more go around, have the seller sign. So let me show you what you would do. I know it's confusing, but nothing's an issue till it's an issue. So here I am at the bottom of the contract. The time limit was 3 o'clock. Seller signs it. Seller fills in the binding agreement date of today, and it doesn't have a time anymore, but it doesn't go back till 6 o'clock. You buyer's agents, what you would do at that point is you would have your buyers initial this and then send it back, because in essence, that constitutes a counter offer from the seller. And your buyers need to sign it and send it back. So I know it's picky, but it would be, and I'll show you in the contract more where it talks about binding agreement date, but I just wanted to let you know that. If there's no time limit, you're not required to put a time limit on an offer. But if you write an offer or a counter offer without a time limit and you want to take that off the table, you agents, you need to remember to withdraw that offer. So let's say a buyer's agent writes an offer on a property with no time limit. 3 days go by, you don't hear anything from the seller. Buyers are like, well, forget it. I'm going to go find another house. You go find another house. If 5 days later you get it back with the seller's signed signature, the buyers are now under contract. So it's not as important with buyers if you have a due diligence, but sellers with a counter offer, you need to remember that. So here's my point of practice. If there's no time limit, then y'all need to remember to withdraw the last offer or counter offer to take it off the table. And there is this form F-285, notice to withdraw offer or counter offer. Notices, that's the next section. It must be in writing, legible, and signed by the party giving notice. Agent email to email does not constitute notice. Phone calls do not constitute notice. Text messages do not constitute notice. It must be done by email, by in person, by courier, or by U.S. certified or registered mail. It is by email. It is considered received when the sender can prove they sent it, regardless of when the receiver actually opens their email or reads it. And it must be emailed or faxed to the address on the signature page. So agents, a lot of you guys, pre-printed on your purchase and sale agreements will be an email address, for example, given to you by your broker, but you do business in another name. So for example, pre-printed on my contract, it could say Dana@MaximumOneRealty.com, but I do business at Dana@thehouseholdname.com. Well, agent to agent, I'm doing Dana@thehouseholdname.com. Well, notice if that notice was sent to that email address, but that email address was not printed on the contract, notice was not served. So y'all need to check your contact information on the purchase and sale agreement. And also, a lot of times, your company's fax number will pre-print on the purchase and sale agreement. I would take that off because a lot of times your company might not give you a fax if it comes through, or if you receive a fax on a weekend or in the evening, you're not going to get it. If you have a client relationship with the public, in other words, your buyer or seller have signed a brokerage agreement, then notice to you serves as notice to the client. If you are working with a public person as a customer, for example, you're working with a buyer, but they won't sign a buyer brokerage agreement, or you're working with a seller, for example, for sale by owner, they are a customer. Contact information for customers must be on the signature page, an email address, a fax number, and or an address. For a client, you don't have to put that on there, just yours, but for a customer, yes. Now, if you see on a contract that a broker is working with their public person as a customer, that does not give you, the co-op agent, permission to what we call cross assign. You can't directly reach out to that customer, that public person. That public person has still chosen that agent and that broker with whom to work. It's just that they have chosen the nature of their relationship is that of customer and not client. So again, you must also send notice to them directly, but don't cross assign. You have to communicate with the agent. And again, this form F816 is notice that you could use for general notices. And this section on no authority to bind. Agents, y'all cannot engage your people in a legally binding contract. You facilitate the deal, but forms must be signed by the buyers and the sellers for them to have to be binding upon the parties. Now, default. What happens if a buyer defaults? If a buyer defaults, the seller's sole remedy is to keep the earnest money as full liquidated damages. Seller can't sue them for specific performance. And this, in other words, it can't make a judge make them go through with the contract. And you can't sue for any money the seller has put or spent on, lost on hotels or lost or moving or anything like that. What happens to a buyer if a seller defaults? If a seller defaults, then a buyer can either terminate the contract and get their earnest money back, or they can take the seller to court, and it's called specific performance. And they basically go to court, and a judge would make the seller go through with the contract. If a buyer's going to sue a seller for specific performance, they don't get their earnest money back, and there's no rights to commission yet because it's still a potentially active purchase and sale agreement waiting on a judge to decide what's going to happen. If either buyer or seller default, what happens to the commission? What are the rights of the broker? It says the defaulting party shall pay as liquidated damages to every broker involved in this agreement the commission the broker would have received had the transaction closed. For purposes of determining the amount of liquidated damages, all written agreements establishing the amount of commission to be paid to any broker are incorporated. What are those agreements? Those are your brokerage agreements. And that's what that part says. Risk of damage to, I'm gonna need to go faster. Risk of damage to property. Basically, the property at closing needs to be in substantially the same condition as it was at time of offer. Clean and free of trash, debris, personal property that the seller did not identify as remaining. It also goes on to say, I don't know if it's here. Yes, this says if the property is actually completely destroyed by an act of weather, or burns to the ground, or major vandalism, then basically the parties agree to stay in contract for up to a year, or they can terminate and get earnest money back. Or the buyer can agree to take the house subject to any insurance payments that would come out. So that's all spelled out there as well. And then this part talks about entire agreement modification and assignment. Just briefly, for any of y'all working with investors, investors typically will tie up a property and then look to assign the contract to an actual buyer who's going to live in the property. Just so you guys know, I'm not going to dwell on this in this class, but just so you know, GAR purchase and sale agreements in and of themselves are not assignable unless the seller agrees to assign it. That is spelled out here in this paragraph. If you are a buyer if you're a buyer's agent working with an investor who is going to assign the contract, you want to use this GAR special stipulation 611, where the seller does give you permission to assign, for the buyer to assign the contract. And it goes on to say that amendments must be in writing and terminations. Everything must be in writing. Here is a whole section on assignment. The seller must agree, and this is the special stipulation. And if you forget to use the special stipulation and you go binding, there is an amendment to assign the agreement that is GAR F735 to, again, get the seller's permission for a buyer to assign the contract. I'm going to skip this part for now, but it is in here in these notes should you need them. There is a lot of forms the past 2 years that GAR has created because we have a lot of investors in our marketplace right now. So if you are an agent, feel free to reach out to me. I'll go over this stuff with you more in depth. Just know for investors assigning contracts, there are, again, a lot of forms to make that happen. Again, the extension of deadlines, I already addressed that with respect to the 8-day unilateral extension. And there are other provisions. So these are, let me show you where we are. Oops. In the purchase and sale agreement. Statute of limitations, 2 years, survival. We are under all of this section here. And again, you will have handouts of all of these. There was a question earlier about days. Here's where banking days, business days are defined, as well as a day. So I just wanted to show you where we are in the contract. We are on pages 7 and 8. It's paragraph C for other, which is all of this other legalese stuff, more than you ever thought was in there. So there is a section about FERPTA that has to deal with foreign buyers and their tax status with the United States. There is a section on GAR forms that says no party is required to use a GAR form. And it says, regardless of what we think the GAR forms say, the courts might, if you get in front of a judge may make a completely separate interpretation. It also says that if you have buyers and sellers binding on a GAR contract, what laws govern the contract and timeframes have to do with Georgia laws. Contracts must adhere to laws of Georgia and times in Georgia. And again, we already talked about this. Brokers and agents have no authority to bind the parties to any of the terms. You can fill in the binding agreement date, but you can't bind the party to terms. Okay, so what if there is a dispute over the binding agreement date? Well, the broker may fill in the binding agreement date as a ministerial act. If there's a dispute, it could be resolved by court, but we don't want to get that far, or a written agreement between the buyer and the seller. Now, there is a notice of binding agreement date. Let me go back to here. Let me see what I have. Okay. This is all in this section. There's a whole new section about binding agreement date. And this is really, really important. This new paragraph right here, it was new in 2023, I believe. This is really important. This section right here says because the binding agreement date's important because of the contingencies. Binding agreement date is day 0 for purposes of counting. But the problem is, if you have one party that thinks the binding agreement date is today and another party that thinks the binding agreement date is tomorrow, then if they send a termination, are they in prior to at the last day of that contingency? Are they in that contingency or not? So here's the important thing. Let's say you as an agent, you get a purchase and sale agreement. Okay, let's say buyer writes an offer to a seller. We're going to take the time limits out of it. No time limits. Buyer writes a seller to an offer today, and the seller signs it tonight at 11 p.m. Now, we know binding agreement date is notice of acceptance. So we have an accepted contract, but it's not binding. They fill in the binding agreement date 2/22/24, but they don't email it back to the buyer's agent until tomorrow morning at 8 a.m. So they accepted it on 2/22, but they sent notice of acceptance on 2/23. So you as a buyer's agent, you get a purchase and sale agreement. The binding agreement date is filled in as 2/22, but they actually sent it on 2/23. What's the actual binding agreement date? Type it in the chat. Yes. Yes, the most of y'all are correct. The binding agreement date is actually 2/23, notice of acceptance. However, if you get a contract and it has 2/22 on the bottom of it, and your buyer has a 5-day due diligence period, well, when is their due diligence up? Is it up 22, 23, 24, 25, to 22, 23, 24, 25, 26, 27th? Or is it up the 28th? You think it's up the 28th because you think the actual binding agreement date is the 23rd. However, the seller thinks it's up the 27th because they think the binding agreement date is the 22nd. Here is a very, very important thing. This paragraph L. If the buyer or seller objects to the date entered as the binding agreement date, then within 1 day from receiving notice of the binding agreement date, the party objecting shall send notice of the objection to the other party. The objection shall be resolved by a written amendment between the buyer or the seller by executing a binding agreement date confirmation. The absence of an agreement on the binding agreement date shall not render this agreement unenforceable. Here's the important thing, what I have underlined. The failure of a party to timely object will result in the parties accepting the binding agreement date as entered. You buyer's agents, you get a binding contract, you get notice of acceptance on the 23rd. That's technically, by the definition, that's the binding agreement date. However, the contract has the 22nd written in it. If you do not make an objection within 1 day of that, guess what? Failure of party to timely make an objection will result in the parties accepting the binding agreement date as entered. If you don't object to that, then guess what? The binding agreement date just now became the 22nd, even though you received it the 23rd. Don't lose a day of your buyer's due diligence period. Pay attention to this information. That's brand new in 2023. And then this section here is, we already know this, I mentioned earlier, a special stipulation takes precedence over an exhibit, which takes precedence over the handwritten or typed provision, which takes precedence over the pre-printed contract. All of that to say, however, the amendatory clause in an FHA or VA exhibit controls over all of this. What does that mean? Well, the amendatory clause section has to do with the appraisal contingency for a buyer getting an FHA or VA loan. And basically what that says is if the property does not appraise for sale price, now in the FHA, you spell out the actual dollar amount, and in the VA, it's a reasonable value as established by the VA, but in essence, the sale price. If the property does not appraise for that, a buyer may terminate through day of closing and get their earnest money back. So what does this part mean? This means that even if you get a contract, if it's an FHA or VA loan, and even if there is a special stipulation that we were calling the appraisal gap stipulation, that the buyer agrees to pay X amount of dollars over a low appraisal, that is not enforceable for a buyer getting an FHA or VA loan. It's trickeration for you listing agents. They can still terminate and will get their earnest money back. And I'm going to finish up this and we're going to get to those loan contingency exhibits. Again, survival of agreement. This is what survives the agreement, meaning this is what the parties are still legally obligated to after closing, and has to do with commission, warranties of title, representations of the seller, if it's condemned, attorney's fees, prorating taxes, devices and fixtures, so forth and so on. Additionally, this is the most important part of this. Any obligations which the parties agree shall survive closing. So remember, I told you the magic word, this provision shall survive closing. If you do actually negotiate for repairs, you want to put in this provision shall survive closing. So if the seller does not complete the repairs prior to closing, they would still be legally obligated to do that after closing. Again, the definitions of the days. This is new in 2024 to disclose to our public what a closing is. The transaction actually closes once everything is signed and the money has changed hands. That's the important part. So sometimes you close, you sign all the paperwork, but if you're closing late in the evening or on a weekend, the money may not change hands until the following business day. So this defines what a closing is. Lots and lots of cyber fraud. This is very important. Y'all need to make sure your people, before they send money by wire especially, just double check by a third party the account numbers and the names where they're sending money to. This is brand new in 2024. Again, as I mentioned, we have a lot of seller fraud where bad guys are impersonating sellers of land and vacant houses. Huge issue. This is limit on broker's liability is not greater than the amount of real estate commission paid, or if it didn't close and there was no commission paid, $100 is the extent of the broker's liability. And this it talks about exhibits. One thing, let me just point out while I'm here, all exhibits and or addenda attached, listed, or referenced are part of this agreement. This is really important. There are some times where you will mark an exhibit. Let's say you include a, I don't know, any of them, Community Association Disclosure Exhibit. You mark it here, you put Exhibit A, but you fail to attach it to the contract. You agents, don't let your people sign this contract until you get a copy of it, because even if you have not laid eyes on it and it's not attached, the fact that it is referenced here in this section, it is part of the contract. So you want to know what that is. And we've talked about special stipulations. All right, that's it for the purchase and sale agreement. Fast and furious. Let's move on to loan. All right. Conventional loan exhibit. For those of you guys that have not taken a changes class yet, one of the first things you'll notice is they have removed a column in 2024. This is the conventional loan contingency exhibit. It's a first mortgage or a second mortgage, the loan amount, the term, the interest rate, rate type. It used to say source of loan, institutional, seller financing, or other. They took that out. Again, per license law, if a contract is subject to financing, it is a license law violation to leave any of this information blank. This next section about using a particular mortgage lender. You would identify an approved mortgage lender. This is not required. Buyer's agents, you probably do not want to identify a particular mortgage lender here. Seller's agents, you probably do want to see a particular mortgage lender here. Why? Well, this has to do, it says right here, nothing herein shall require the buyer to obtain mortgage financing from this person. However, the rest of this document says that if a buyer is going to terminate based on a financing contingency and get their earnest money back, that loan denial letter must be from, if there is an approved mortgage lender identified, it must be from that person. So you buyer's agents, here's the problem. You'll put down one approved mortgage lender and your buyer will end up going with another lender. They get denied the loan. You get a loan denial letter from lender number 2 that wasn't on here. You can't even get a loan denial letter from the lender that was identified on this because they never went with them. You've just lost your buyer's earnest money. So be really careful about that. Now, you can include a loan pre-approval letter. That has no bearing on the contract. That's just additional information, but it's just who you identify here. And here's where you fill in the time frame. This is the number of days from binding agreement date that a seller gives a buyer the opportunity to convince a lender to lend them money. This is what we think of. Can a lender require a buyer to put? No, absolutely not. A lender does not sign the contract, is not party to a contract. A lender can't require a buyer to do anything, just like we can't require a buyer to do anything. No, you just leave it blank. Oh, great question. Good question. Very interesting, Marcia. Because I said at the beginning not to leave any blanks. It is applicable. I would leave it blank, or I guess you could put NA. Oh, that's nobody's asked me that before. That's a good one. And it says, unless an approved is identified below. So if they don't put one, then a loan denial letter can be from anyone. So Yep, I don't know. Ask your broker about NA or leaving it blank. I think in this situation, it would be okay to leave it blank because it isn't anything that's actually negotiated between the buyer and the seller. This next section, we always talk about it as the appraisal contingency time frame, but you guys be really, really careful. This is, again, blank number of days from the binding agreement date. This is not a time frame for a buyer to terminate if the appraisal comes in. No, I would not put to be determined. I would leave it blank or put NA because you don't want to, buyers, y'all don't want to identify a mortgage lender. I'll show you something later on. I would leave it blank or NA. This is not a time frame to terminate. If you have, let's say you have 21 days from binding agreement date here in paragraph 4. If the appraisal comes in low, that does not mean the buyer has 21 days to terminate based on a low appraisal. It even says length of time for buyer to request a reduction in the sale price. And I'll show you where that is. You buyer's agents, if you get a low appraisal and send a termination to the seller within this 21 days, you've just lost the earnest money for your buyer. You have just defaulted your buyer. Now, let's go back to the mortgage lender. Buyers may apply for a different loan, a loan denial letter, not only if you identify an approved mortgage lender here, and you can put more than one, not only must that denial letter be from that person, if it's blank or NA, it could be from any mortgage lender licensed to do business in Georgia. But the loan that's denied must be this loan. So you listing agents, watch out for the trickeration, because a lot of times a buyer will make the contract contingent upon one loan amount and terms, and then they'll go for different terms. They get a loan denial letter for the different terms. They would lose their earnest money. The loan denial letter has to be for a denial of this loan that they agreed to make the contract contingent upon. Appraisal contingency, how many days? Yeah, that's completely, Monica. You need to check with your lenders. You need to see what time frames the appraisals are running. If it's a tricky appraisal, those are questions that I would get guidance from my lender first, from the buyer's lender first, and then negotiate with the seller. So the loan denial letter must be for the loan described above. Loan denial of such other loan shall not be the basis for the buyer to terminate this agreement. Now, here's another thing. We're on the conventional, if the purchase of the home is contingent. For the appraisal contingency, how many days is most correct if the purchase of the home is contingent with the sale of the buyer's property? Again, they're completely separate issues. A sale or lease contingency has its own time frames. Appraisal contingency, the buyer still has to pursue this loan for this house and this appraisal. So again, that's a discussion for with your lender. An appraisal contingency on the new house has nothing to do with the contingency for the sale of their previous home. That would be up to a buyer. Might not want to go under contract on a new home, or seller might not accept a contract if the buyer's sale contract on their current home, if it's not even listed. I don't know of a lot of sellers that would accept that contract. Okay. This is the conventional loan exhibit. A lot of times you will have buyers that talk to the lenders and the lenders say, oh, I can get you a better deal with FHA. You guys, notwithstanding the above, buyers shall not have the right to apply for an FHA, VA, or USDA loan unless the parties agree to amend this agreement to add FHA, VA, or USDA loan contingency exhibit, as the case may be. And if that happens, in which case this conventional loan contingency shall no longer be part of this agreement. Nothing requires the seller to agree to an amendment. So you buyer's agents, your buyers can't just automatically, magically switch to an FHA or VA loan if the seller doesn't agree to it. All right. Now, here's the thing. If you don't identify a mortgage lender here, as soon as the buyer does find a lender with whom they are going to work, buyer, even if you do up here, When it is known, buyer shall promptly notify seller of any mortgage lender to whom the buyer has sent notice of an intent to proceed with the loan application and the name and contact information for the loan originator. Now, this next section is the financing contingency in and of itself. Again, the seller gives the buyer X number of days to talk that lender into lending them the money. If they can't do it, then the buyer must send a termination notice prior to that time frame and prove it with a loan denial letter. The loan denial letter may not be based solely on buyer not having the money other than the loan. In other words, if the buyer doesn't have cash to close, nope, they're not going to get their loan, but they're going to lose their earnest money. If the buyer has to sell or lease, sell a previous house and they didn't make it contingent on that, they don't get the loan, they'll lose their earnest money. If the buyer does not provide the lender in a timely manner with all information required by the lender, including documentation, they'll get denied the loan, but they'll also lose their earnest money if that's the reason on the loan denial letter, because that's not the terms. If the buyer makes a purchase that adversely affects their debt to income ratio, in other words, the lender pre-approves them based on their credit score now, then President's Day sale and they go and buy a whole house full of furniture on credit. Now they're outside of the credit, their credit score has changed or their debt to income ratio has changed. They get denied the loan. They will also lose their earnest money. If it doesn't appraise, if it's subject to an appraisal contingency, not subject to an appraisal contingency, and if the lender hasn't completed underwriting by the time, they will lose their earnest money. Make sure your buyers understand this. Then if you get past the financing contingency and they had not terminated, then the seller can ask for a loan commitment letter. And if they don't get it within these timeframes, the seller can terminate. This is where buyers and sellers give the lenders permission to talk to the agents. Now, let's talk just a little bit. I know we're running out of time, but hang on one more second. This is the appraisal contingency. So again, let's say we filled in 21 days in paragraph 4 up here. Let's say we have 21 days there. What this all spells this out. Basically, if the property appraises for less than sale price, the buyer has 21 days from binding agreement date not to terminate the contract, but you have to give the seller the opportunity to agree to sell it to the buyer for that lower appraised price. So that 21 days is the time frame to send an amendment to the sale price. It's right here, amendment to sale price, F713, and a copy of the appraisal to the seller to let the seller decide if they're going to sell it at the lower sale price. If the seller agrees, the buyer has to go through with the closing. If the seller does not agree within 3 days, then the buyer has 3 days to decide, am I going to go through with it or am I going to terminate? So buyer does have termination rights with protection of earnest money after these time frames, but that initial 21 days is to get the amendment and a copy of the low appraisal to the seller. Seller has 3 days to decide. If the seller says no, then the buyer has 3 days to terminate. That's all been in there. That is just now spelled out. So that is the conventional loan exhibit. Let me show you guys. I've got 1 more minute. Give me 1 more minute to show you something brand new on the FHA and VA loan. All the rest of this is the same. However, for an FHA or VA loan, there is no appraisal contingency. It's called an amendatory clause. And as I mentioned at the beginning, if the property on the FHA appraises for less than this, a buyer does have termination rights through day of closing. They can't just not show up, but they can send notice of termination and they will get their earnest money back. However, brand new in 2024, you agents, this is really, really important because this is new. FHA, it's on the FHA and the VA loan exhibit. further agreement to pertaining to the amendatory clause. It used to be a low appraisal, buyer could immediately terminate. Now, with this brand new paragraph, the buyer, an FHA and a VA buyer and USDA, if the appraisal comes in low, you have to give the seller the opportunity to agree to sell it to you for the lower appraised value. So once you get the lower appraisal, buyer shall immediately provide seller with written copy of the appraised value. Seller then has 5 days to agree to sell it to the buyer at that lower amount. If they agree, the buyer must go through with it. If the seller does not agree to reduce the purchase price, then the buyer still has termination rights with protection of earnest money. But this is very different than it used to be. You have to now give the seller the opportunity to sell it to you for the lower appraised value. And on the FHA, you have to fill in mortgage insurance premium. The seller is required to pay tax service fees on an FHA loan. And if the FHA appraiser mandates repairs, you negotiate in advance. Buyer or seller is required to pay those FHA commitment repairs as long as they don't exceed this amount of money. If they do, this paragraph tells you what happens if the repairs are more than this amount of money. You get third-party estimates and agree who's going to pay them. And if you can't agree, then it will terminate and buyer gets their earnest money back. Same thing with the VA exhibit. Again, brand new, everything is all the same. The only difference is, where is it? Termite letter. I don't have it yet. Here again with the amendatory clause, which is the appraisal contingency, if it comes in low, you have to give the sellers the opportunity to agree to reduce the price and sell it to the buyer. Additionally, on a VA loan, there is a termite clearance letter required. New a couple years ago, buyer or seller can pay for the initial letter. If there are repairs required, and a second letter, the seller is required to pay for a second letter. So that was the fast and furious rendition of the purchase and sale agreement and the loan contingency exhibits. Again, termination and release. Again, we've addressed this with earnest money. Again, for the termination, it's only one party terminating, and that signature of party, either buyer or seller, but buyer and seller must agree to the disbursement of the earnest money, or you have all of those other options available to you. Again, I do have these notes available to you along with all of my underlines. I will stay on to answer questions. You are free to go. I thank you guys so much. One more time before you leave, please type in your name, your license number, and your email address in case we have any issues. And I thank you guys so much. Pretty in-depth look. We dissected it pretty well, that's for sure. And again, hello, everybody, my friends. It's good to see you guys. New people, welcome. I hope you take another class through our school or with me as an instructor, and I will be more than happy to stay on to answer any questions that you have. Thank you guys so much. Go be a blessing with your real estate license. There are people that need houses. Houses are still selling every day, every day, every day.
Hey, this is Diane Allridge. Could you give us the address to where to get the handout that you were speaking about at
Yes,
the beginning of the class?
absolutely. We are looking to make it easier for y'all in the future, but for right now, you go to eagentweb.com. For those of you on here, I'm going to share my screen. I'll show you guys exactly how to do it. Let me get out of this. You are going to go to eagentweb.com. Again, I'm the broker of Maximum One Greater Atlanta Realtors, so it does show It does show maximum on Realty. And you click here where it says training videos. And you just scroll down. And you will see this is where right now we are looking to put it on the actual Academy website. But for now, this is the 2024 GAR contract changes. And all of these red things are handouts. So again, I'm going to put it up at some point today, this class with these handouts. But you would get, here's the, for example, the purchase and sale agreement. You click on that hyperlink and it will give you the PDF of it that it takes a minute and that you can then download. And again, all of my handouts with all of the underlines and everything are there. So again, eagentweb.com, training videos, and then you scroll down the page. And we have all of our classes here. You guys we believe so much in education. You are more than welcome to watch videos of recorded classes and download any copies of any materials that we have. So I hope that helped. Anybody else?
Hey, Dan, this is Josh Proctor. I just had a quick question. Back in the section when you were talking about the prorations of taxes, after the sale has been completed, and the tax bill does come in, if it was higher than what the closing attorneys did estimate, is there any legal obligation as far as that additional amount from the seller to help compensate the buyer for those, or is it solely up to the new buyer?
So the buyer and seller agree to prorate. So this is, you guys, what people agree to and what's enforceable are two separate things. So let me go back here. Let me share my screen. I'll show you what it says, and then I'll give an example. So here's what it says. In the purchase and sale agreement under the section on prorations, here we go. Did I pass it? Yes. Prorations. It says ad valorem taxes, which is property taxes, county and city. And it says in the event ad valorem taxes are based upon the estimated tax bill or under appeal. Okay, wait. This also says let me make this a little bit smaller. Any pending tax appeal. Okay, let me go up here. Ad valorem taxes. Here we go. Ad valorem property taxes, community association fees, solid waste and governmental fees and utility bills for which service cannot be terminated, cannot be terminated as of the closing date, shall be prorated as of date of closing, notwithstanding any provision to the contrary. In the event, buyer and seller shall here it is right here, buyer and seller shall upon the issuance of the actual tax bill or the appeal, if it's being appeal being resolved, promptly make such financial adjustments between themselves as are necessary to correctly prorate the tax bill. So what this says is buyer and seller agree after closing, when the real bill comes out, if it's different, to go back to each other, and seller agrees to pay more or buyer agrees to pay more, or what it says they agree to settle that up between themselves. Do they do that? It's just like any contract provision that is broken, any default on a contract. You know, it's the groundwork. Should they not? And the enforceability of it versus the legal right to it are two completely separate things. So if they do not agree after closing to prorate between themselves, then one of the parties has the opportunity to hire an attorney to go pursue the other one legally for them to enforce that provision of the contract. And that's one of the survival things, is the section on ad valorem property taxes. So there is grounds, and their attorney would have the legal groundwork to sue them for their additional proration of the taxes.
Makes sense.
Hey,
Thank you very much.
You're welcome.
Dana, this is Earl Randall. How are you?
Doing great, thank you.
Great, great. Two things. One thing I couldn't put in the chat at the end of the class, my name and my license just recently, where on the GAR form where it says seller contribution to closing costs, I've always, if the buyer's going to pay closing costs, put 0. I got a call from the listing agent, the seller's agent, saying he took that to mean that the buyer was going to also pay all the commission because I put 0 there.
Closing costs have nothing to do with commission. Commissions are all addressed in the brokerage agreements.
That's what I tried to tell him, but he insisted that that's what his seller interpreted, and that's how he interpreted. So
That's
I
incorrect.
didn't know if I needed to start in the future putting in the special steps, buyer will pay all closing costs except commission, or is this just one of those strange things?
This is just one of those things. Do not do that, because, and that I wouldn't use that special stipulation, buyer to pay all closing costs. Well, seller has closing costs too. Does that mean the buyer's going to pay the seller's closing costs?
I see.
Yeah,
Okay.
no, I think that's just an anomaly. That is, and I would get with that person's broker, because that's just it's I mean, I have a feeling what the guy is thinking about is that new provision that GAR added last year that says if there's any overage, it can be used for a buyer's commission obligations. And again,
Right.
it's just if there's a shortfall between what a buyer agreed to pay a buyer's broker in the buyer brokerage agreement and what the buyer's broker is receiving from the listing broker and or seller. If there's a shortfall and the seller had agreed to make a contribution to the buyer's closing costs, then those funds can be used towards the buyer's commission obligations should there be a shortfall. But it has nothing to do with any and all commission whatsoever. And even that, though, how do you know there's a shortfall? Well, it still refers back to the brokerage agreements. So yeah, I think that's
Right.
an anomaly, a misunderstanding.
Okay.
Question. Are
I
you
have a
seeing a lot
question.
of buyers paying their agents commissions? This is looking like, based on all of these national lawsuits going on, which are going to go on for years and years, just so y'all know, it is looking like there are a lot of places where sellers are, okay.
I was wondering if you have a home that requires flood insurance, and sometimes I see that it will actually say that in the listing. And I was wondering, is that a good practice that you put that on the listing, or should you just let them figure that out in due diligence, or just wondering what's the best practice for that?
Well, let me ask you, what would be nice for you to see if you're a buyer or buyer's agent?
Yeah, it would be nice, I think, to see it in the listing, but I guess also as being the listing agent, I wonder, will that distract, or I should say, keep anyone from actually even coming to see it, or
Well, let me
I
ask,
don't know. I
let me
think
ask you
both
another
ways
question.
about it.
Let me ask you another question. Would you rather have somebody not
Yeah,
go
I
under
know,
contract and terminate under
and
due
then I
diligence?
know,
Don't waste your seller's time. They're gonna find out anyway. So I
yeah,
would disclose it. It's still up to them to determine that, but if somebody refuses to buy a house in a floodplain, don't tie up the house or time when you could sell it to another buyer that doesn't care or is willing to pay that. So I would, if you have that knowledge as a broker or as an instructor, I would disclose
just put it in the
any and all
listing.
information you have and let every house sells. It's just a question of, is it priced appropriately for the location and the condition? I mean, everything sells. If it's priced right, it'll sell. But for everything that it has to offer, condition, being in a flood zone is part of the condition. If a buyer can't buy it, you know, and it's not, well, I started to say it's not fair, but you know, to a buyer's agent, they're going to show that house. The buyer's going to fall in love with it and then not be able to afford the flood insurance or not want it. And then you know how it is. You see something you can't have. Now, what you can't, you don't want your buyers, we never want our public settling for a house that they end up buying. We want them to fall in love with that house.
Right.
So I would encourage the seller to disclose that if that's known.
I just have one other thought. I noticed somewhere in the GAR form where that you went over where it said something to the effect of no one is required to use these forms. So
Mhm.
what about when, let's say, if I am not a member or if I'm using the RE forms and then another agent is saying, no, you have to use the GAR forms.
So what does license law say about offers?
About offers
Mhm.
that they have to be written.
You have to present. All agents must present all offers,
Right.
regardless of what form it's written on.
Right.
And I would venture to say that that agent probably misunderstood their broker. Because if they say they only accept GAR forms, that means
Right.
none of their agents can write new construction when it's written on an Atlanta builder's contract, can't help their buyers with HUD homes,
Mm-hmm.
can't do attorney written contracts. So I'm going to say that agent misunderstood their broker. You have to present all offers, period. Only an attorney can dictate a form that their client writes something on. If you write an offer on an RE form and the seller doesn't want it, wants it on a GAR form, well, simple. The seller just makes a counter offer on whatever form they choose.
Mm-hmm.
So they can write a counteroffer. Now, a broker can have a policy that I require for example, a broker can say, I require my agents to initiate all offers on a certain form, but you cannot require a form that a public person uses. And I don't think they're doing that anyway. Like I said, that means their agents can't help buyers with new construction where the new construction
Right.
contract
Is
is a
on
GAR
their own
form.
form. Right. Interesting. Thank you.
You're welcome. Mr. Hornsby, spiffy as ever. So good to see you, my friend. You too, Miss Cartwright Williams. Anybody else? Hey, Linda, I didn't see you. You're at the beach. I want to go. All right, everybody. Thank you all so very much.